Right. So we're on day 3, and we have covered the nature of the problem we're trying to intervene in. We've talked about the structure of organizing, at least in a Duluth model context, and some of the different ways in which people do organize and what the pros and cons are. We've talked about how to start discovering problems, other than just what advocates hear from victims or from things that you come across in your daily work, but looking at things like observations as a tool to start looking for gaps in the system, doing focus groups as a way to expose the gaps in the system. But neither one of those things, as we've talked about, will tell you why the problem exists. It'll just tell you that there is a problem. And then so that's where the CCR coordinator or the team starts doing investigative work, becomes forensic investigators, as Mr. Garvin has suggested, to figure out what the sources of those problems are. And then when you find out what the problem is, then we've talked about the different ways in which organizations get structured to standardize workers' actions. And if you build your solution through that lens, then it's likely to be a lot more sustainable within that organization than if you don't. So that's kind of where we are to this point. This morning, we're going to have, as I said yesterday, a speaker, the lead prosecutor for the Stearns County Attorney's Office in Minnesota, talk about the utilizing expert witnesses as a tool, as an intervention that you can create within your CCR to help get convictions when victims recant. So as one reason, or all the different kinds of counterintuitive things that happen that the general public isn't going to have any insight into as to why those things happen. So that'll be a particular intervention that you can add to a CCR. And then we're going to talk about basically how to track and monitor your work in a CCR after that presentation. And then we're going to move into how do we then shift to a plan? Given what you know about your communities, where do you want to go next? And really that'll be a conversation for those of you who have other team members on the call. We'll put you all together and you can have that conversation and come up with a plan. And then I would suggest, and I don't know if David would want this or not, but I thought it was a good idea. So I always like to pop it on David without asking him first. Is everybody, when you come up with that plan for your community, back to what David was saying about how they can support you, send the plan, send the rough draft or outline to David so he knows what you're trying to achieve in each of your communities. And then he might have a better idea about how to support you in doing that work, because you don't want to do this work in isolation. You really don't.
I would love that.
Yeah. Good. Now I'm batting 2 for 2 on that, on suggesting things for David that that I thought was a good idea. Okay, so open it up for questions, comments, thoughts, where we're at now, yeah, just how what are you thinking about applying this to your work in your community? Or I'm even thinking of like Matt, like from the health sector, right? How are you thinking about this work related to what you do?
Well, I guess since you mentioned my name, I'll add a few thoughts as I'm thinking out loud.
Sure.
Only had a half a cup of coffee, so one of the things that rang true for me in what you were saying, I wasn't able to attend the full day yesterday, but you talked about organizing and health promotion from the organizational perspective of Department of Health is very much an organizational work. We are on the ground talking with community partners 80% of the time, rarely in my office, outside of COVID stuff that has taken over a lot of my work. But mainly with partners working on upstream stuff. I don't deal with a lot of downstream things. And some of the conversations I'm in shift or try to separate health from health care, because health is a much broader component than health care. I'm not a
Right.
clinical guy at all. One thing that this directly ties into are the conversations we're trying to have with APD, BCSO, law enforcement. To DOH and law enforcement don't talk right now in an organized way, and we're trying to fix that. That's been a
Okay.
real uphill battle. We've had a couple of conversations. A lot of community conversations that I'm in always talk about safety and law enforcement, but yet we don't talk directly with them. So
Yeah.
I'm not quite sure how that fits into what you're asking. You know, so yeah, that's a few thoughts that I've got right now. Of it's been eye-opening to see this part of the downstream of domestic violence and how things are prosecuted and dealt with after the events. A lot of our focus from DOH is trying to, how do we get there before this process is even happening?
Right.
Yeah, but
Yeah.
I'm glad I'm here.
Yeah. Yeah. So this is something that pops into my head from what you said, Matt, is so for a law enforcement officer to be able to be positioned to perform at the top of their game, right? One of the things that happens within the culture of law enforcement is that there's no place to go for the trauma they experience. And so it comes out all kinds of different ways, right? So building a formal way for that to happen within agencies, that officers have a place to go without looking weak, without looking like they're vulnerable, right? So that because that is the culture, right? You're not going to change that, but you can develop mechanisms for people to have a place to go, to deal with what they have to see on the street. I mean, if you do ride-alongs, I mean, I remember my very first ride-along. It's a domestic violence offender that they're going to find on a warrant status, and I'm walking up with the investigator, and we get up on a porch, and he knocks on the door, and he stands to the side, and I'm standing right in front of the door, and he said, "You know, buddy, you might want to move to the side in case he blows a shotgun through the door." It's like, oh, yeah, okay. Like, I mean, my level of alertness is not there, and when you start listening to those folks talk, it's like, there's red light, there's yellow light, there's green light. And the only place that my light goes green is when I'm in my home with the doors locked. Otherwise, I'm always either on yellow or red alert, right? And there's a cost to that, right? That we have to appreciate when we're organizing with that agency, right? So these are the kind of things that Matt's aware of, that maybe the rest of us might not be if we haven't been in that space very often, that have to be accounted for when we're asking them to do something different, right? Because that's the culture, that's the space.
Scott, what do you think of hospitals doing universal screening for domestic violence?
You know, I think it's something to do, that they should be doing, but the way that they typically do it, I know doesn't seem to work. Because did I mention that on this call yet? Being in the ER, watching a woman. Yeah, so my son has cut his leg on his bike, and we're sitting in the ER waiting room. There's a woman on the couch across from me on the phone with a friend of hers, telling her friend how she just got beat up by her boyfriend. So I'm listening to this whole call, right? So now she gets called to the triage nurse, which is not a private room, but just right around a corner, right from the waiting room. And she sits down and she says, you know, I've got this, my arm really hurts on my shoulder and I have a hard time lifting it. And there were some other bruises on her. And the nurse said, I need to ask you a question. Do you feel safe at home? She goes, yeah, I just fell around the couch. Okay, well, so that was just fascinating to me to watch from this end to that end. It's not private, right? Oftentimes he's with her in the waiting room, and you're asking if you feel safe. So now she leaves. I walk up with my son, who's 8 years old. This is the second time he cut his leg on his bike within 2 months, and he needs stitches. And the nurse says to my son in front of me, "Do you feel safe at home, young man?" Well, what's he going to say? I'm sitting right there, right? So when I asked a couple nurses that I knew who were nurses personally, I said about this experience, they said, we don't really want them to say yes, because if they say yes, it kicks a whole bunch of stuff in. Like if they really need help, I hope they say it. But if they say yes to, I don't feel safe at home, I got to call a social worker. I got to deal with, like, it just stops everything. Right. So there's almost this feeling like, I hope it's a no. And we create an environment where it almost is always going to be a no. Right. So, so that's really interesting information. Again, that's the culture, good, bad, or ugly. I don't want to make a judgment on it, but it's what it is. So if that's what it is, then how do we organize within that? And what most of the women that I've talked to who've reported to a physician, it's when they're in the exam room and there's a power and control wheel on the wall, and the doctor asks if anything on that wheel, is something that she's experiencing. And if it's private and he's not in the room and it's with her physician, that's likely the private space that she's going to say something. It's not going to be in an open triage nurse sitting, in a non-private setting in an ER, right? So, so again, I don't know. I don't have an answer, David. I just know that that system has as many issues around organizing as any of the other systems that we've been talking about. Angela, you get your hand up.
Just speaking to the hospital setting, I was recently in a training with some of our SANEs that one used to work in IT at the hospital before she became a nurse, and then became a SANE. And once she started working as a SANE, she, recognized an issue and figured out a way to fix it. And I thought it was a wonderful idea. I haven't approached our hospital about it yet, but she said there are IT workarounds to flag any chart that reports domestic violence or has concerns or whatever, so that they can have a notification pop up that they need to contact programs like ours. So
Yeah.
I thought that was really cool.
Yeah, no, that's great. That's good. Yeah. Other thoughts? Leonel, now you got me nervous. I was going to blow it. I got it right the first time. Now I was going to blow it the second time.
So like a year ago, my wife and I had a baby, and it's crazy how you mentioned that, because we were in there and I was in there with her, and then suddenly the nurse tells me, "Hey, can you step out?" And I'm like, "Okay." But at the moment, I don't know why, right? And I thought something like that. And then after I come back, my wife tells me, no, she told me if I was safe, if I was in a domestic relationship. But basically, she was there making sure she was safe.
Yeah.
So I mean, what if what if I didn't want to leave?
Right. Yeah. Well, if you didn't want to leave, that would tell you something. I think if you were a medical professional, right? Yeah.
So,
Good. Thank you.
I've seen it work well, and I've seen it be like Leonel's experience. I've seen it where they asked me to leave, and another time I saw it where my wife was in the hospital. She happened to be in the bathroom in her room. Nurse came in and said, where's your wife? I said, she's in the bathroom. She said, well, you can answer this question.
What? You were going to answer whether she feels safe?
Yeah.
Okay, that just tells you I don't want to know the answer. Yeah. Wow. That's an extreme version of that. All right. So in preparation for the call that we're going to have in 10 minutes, how many of you have ever had to testify in court in a criminal matter? Anybody on the call? Jackie, okay. Angela, Erica. Okay, so what was the reason you were testifying? Were you a witness to it? Jackie?
Witness.
Witness? Angela?
I've been a fact witness and an expert witness.
Oh, you've done both in New Mexico. Oh, cool. So we got somebody who's actually done that. Erica.
I used to work for Child Protective Services as an investigator, so it was part of a case that I had worked previously.
Okay. So again, one of the things to know about testifying, and I'm going to put an article that Melissa Skine and I wrote about just preparing to be an expert witness in a criminal trial, so you can kind of see what kind of some of the prep you need to go through. But if you don't have a CV, start to build one, right? Like all the trainings you've been to, any trainings you've done, anything that you've ever published, start getting a chronological order of that put together. And the burden really for an expert is quite low. It's just basically having more knowledge than the average person about a subject, and this in case domestic violence. And there's one of the things that we do here in Duluth for new officers is do we have a judge, a prosecutor, a defense attorney that take those new recruits through a short training on how to testify, right? So, and it's some really basic stuff, but you're going to dress in a way that is fairly conservative, with your tie. I'm not going to have the Ocean's 11 look going on that I have today. I'm going to have a more conservative suit. It's going to be a conservative tie. When I walk into the room and I take my oath, right? I don't just like this, right? I mean, it is, right? I stand at attention and I take the oath because it is serious. Those 12 jurors who are watching you have all taken that oath. They're taking their work and their decision-making very seriously. And I want to make sure that they understand that I'm doing the exact same thing, right? And I only answer questions that are asked of me, right? If I'm not asked the question, I don't answer. If I don't understand the question that I'm being asked, then I can ask for it to be clarified. Sometimes the defense will ask me multiple questions in the same question. And I'll say, could you just ask me one of those questions first, and then I'll answer your second question, because I don't want to be led to a place that I didn't know I was going, right? And you can testify at your own pace, right? You don't have to testify at their pace. You can testify at your pace, right? They will try to discredit you, right? I mean, that's the defense's job. So sometimes people get really frustrated by that and say they're being mean or they're doing, no, they're doing their job. That's what their job is, right? Is to do everything they can to advocate for their client. And, if you take TV lawyering off the table, their job fundamentally is to push the state to meet the burden of beyond a reasonable doubt, because that's the burden the state has to overcome, right? With the jury, their job is to make sure that the state meets and prosecutes at that burden, right? So you give them your resume, you give them your CV. You typically will have to write up a short little piece about what you're going to testify to in general, right? I will give you all these things that I use so you can see my version of that, and you can develop something on your own if that's what you want to do. And when the prosecutor gets that, they disclose that both my name, what my role in the trial is going to be, and my materials, my resume, the short little piece about what I'll testify to, and my CV to the defense. The defense may depose you. Typically, that only happens if they have a wealthy client. Public defenders aren't going to depose you. They're just going to take what you give them and go forward. And the biggest thing to remember is that you never have to testify to something you don't know. Every question you answer, you already know the answer to it, right? You just got to articulate it. And if you don't know the answer to something, you don't know. You don't make it up. You don't try to answer it. You either know it or you don't. So that's the good thing, right? You already know all the answers. You're just waiting for the question, right? So now if you're a witness like Jackie was talking about, now you're testifying to what you saw, what you heard, your experience in regards to the case. When I testify as an expert witness, I can't know anything, any facts of the case in a criminal trial. I'm only talking about my general knowledge derived from working in this field, right? So some expert witnesses use a lot of research. I don't like to use research. Most prosecutors I work with don't like the research either, because when the research precedes your experience, there's all kinds of things that they can do with the research that just bog the whole thing down, right? But if I say, this is what my experience is in working with victims of domestic assault, and then I back it up with research, it's a little harder for them to attack that, because what's front and center is my experience, right? As opposed to the research. So just in general, I would really encourage people to consider being expert witnesses. Basically what your job is to explain counterintuitive decisions that victims make that the general public do not have insight into. And I use the power and control wheel every time I testify, because it really helps me anchor both the questions from the prosecutor and helps the jury understand the system of abuse that she is experiencing. Now, one question I'll always ask of a prosecutor is, can you, and they don't have to tell me what it is, and I don't want to know what it is, but I need to know that you can demonstrate a pattern of abuse somehow, some way, right? So there was a Minnesota Viking about 10 years ago who was arrested for a severe domestic assault strangulation case. And that was the only event they had on this guy. And I said, I can't, and she testified that it was her fault. There was no history, zero in her testimony to the law enforcement. So I said, the liability of using me is that they're going to be able to say that battering, coercive control, which is a patterned system of behavior, does not apply to this case. Therefore, all of Mr. Miller's testimony doesn't apply to this case, right? And so ultimately they decided not to use me because they couldn't show a pattern, right? If I'm going to testify, I need to know, what I do need to know is the gender of the offender and the gender of the victim. Because a lot of what we know through experience and research has to do with cisgendered heterosexual males beating their female intimate partners, right? But if it's two men, if it's two women, if it's a woman who's the defendant and it's a male, the victim, that changes dynamics. I need to know that before I testify, right? So that's just in general some kind of the landscape that I walk in as an expert witness. And I've testified in federal court, I've testified in state district court, military court, and family court, and in a number of different states. And every one of them has different kinds of ways of of using expert witnesses, but in general, it's all pretty much the same, right? The only thing that tends to really change is how much money the defendant has, because then the more money they have, the more work you're going to have to do as an expert witness. So I see Muriel's on. Hi, Muriel. I'm just talking about rich defendants and the struggle with being an expert in those cases. I was just one quick story. I was at a meeting in DC, a domestic violence thing that was going to go on. So I was at this meeting and I get this call from an attorney in Vermont that had a client who was going up against an order for protection request to reissue the order, and after it expired, and they felt like the other side was using the power and control wheel in an inappropriate way, and they were, and they wanted me to testify to that. So I had a limousine pick me up in rural Maryland and drive me to Washington, D.C., put me up in a first-class hotel. Like, this is just not what Muriel does for me when I testify for her. And flew me to Vermont, picked me up, drove me to the venue. I testified for about 15 minutes. The victim in the case was testifying from her home in Spain. It was like this surreal environment that just is not what we typically experience doing this work. But yeah, so anyway, Muriel is the lead criminal prosecutor for the Stearns County Attorney's Office. I've worked for that office for 10 years, maybe, testifying, I think, close.
Yeah, maybe more.
Maybe more. And I've testified in front of Muriel. So she's going to talk about using expert witnesses as a prosecutor and why that's so valuable to getting convictions in these cases that are complex and difficult to get convictions in. So they all have your bio, Muriel, so they know your background. So I'm turning the floor over to you, and I'll jump in when appropriate.
Sounds good. I think I have a PowerPoint that needs to be put up. Perfect. Look at that service. So as Scott said, my name's Mariel. Just a little background. I know you have the bio, but as I understand it, at least, that most of the people attending this are in New Mexico. Maybe there are some people elsewhere across the country, but in Minnesota, we don't have district attorney's offices. Our district attorney's offices are called county attorney's offices. And so I'm an assistant chief of our criminal division, but in essence, I'm an assistant county attorney, which would be equivalent to an assistant district attorney, I believe, in New Mexico, from what I could tell in the way that you guys divvy up your prosecution. So we have 87 different counties in Minnesota. So we have 87 different county attorney's offices. So I am just representing, I guess, one of 87 county attorney offices in Minnesota. So as you can imagine, in your own state, Minnesota is a large state and probably practices a little different in each county. So I have been a prosecutor for 14 years. And the vast majority of my caseload prior to the last couple of years was intimate partner violence cases. We have a felony domestic violence court in our jurisdiction that deals with repeat violent offenders that get closer supervision for probation, closer supervision from the court, et cetera. And so I've had a lot of intimate partner violence trials. And within the trials that I've had, I've called an expert witness in at least 10 of them. I was trying to, I guess, count, but I've countless times have notified the court that I want an expert to testify and successfully argue that that would be admissible at trial. And then, of course, as we know, most trials end up resolving. So if you want to go to the next slide. And why would you want to call an expert witness in your case as a criminal prosecutor? I think, as hopefully most people know, these cases are one of the hardest cases to prosecute. I probably would have said the hardest until I switched over to prosecuting human trafficking and sex trafficking, because those cases have a lot of the same dynamics, but a lot more trauma. but they're very difficult to prosecute. You're dealing with victims who do have trauma, who have a variety of reasons why they wouldn't leave a relationship, have a variety of reasons why they would be saying F you to me and not wanting to be a part of the prosecution. And so they're very difficult to get in front of a judge, but they're very important cases to prosecute. I have thoroughly enjoyed prosecuting these cases the entire time I've been doing them. It's very rewarding. It can be a high burnout rate as well. I currently supervise our attorneys in our domestic violence unit that continue to prosecute these on a daily basis. So you're going to want to call an expert to testify in a criminal case to explain why your victim might get on the stand and recant and say it didn't happen, or why your victim stayed in an abusive relationship, or why your victim didn't report the rape for 5 days or 2 weeks or 3 months, and why all of a sudden they're reporting now. Also to gain insight into the batterer's behavior. And I assume as Scott's talked about previously and is in the background of his Duluth model is the power and control wheel. So being able to explain a lot of those things and dispel the myths used by the defense, which is spelled incorrectly now that I'm seeing it. But when I'm arguing to a judge, and we can talk about that more, I really focus on, well, the defense is going to get to say X, Y, and Z. They're going to get to say that she lied because she didn't report it right away. They're going to get to say, why would she not leave? If this happened, if this was so bad, she would leave. They're going to get to say all these things that are common misconceptions within the public, within the news, within the media, your friends, your family at the dinner table, constantly questioning why the victim would act in a certain way, because if she was really abused, she wouldn't do this, she wouldn't do that. And so that's why I try to explain to a judge is, well, if the defense gets to do this based on zero actual information from any expert and act like it's common sense, then I should be able to get to at least bring an expert in to explain why and how it's common that victims in general of battering would act in a certain way, and let the jury decide which one of those makes sense. So the next slide. Do I need an expert? Common victim behaviors that I will want to explain to a jury or to my trier of fact is if the victim is denying abuse, the delayed report, minimizing, recanting, staying with their abuser. A lot of times we have our abusers talking to their victim in jail phone calls. Many times those are, I love you. They're not usually threatening, but what that means to that victim, and telling other friends and family the abuse didn't happen. I know there's, I don't know in your guys' area, it didn't seem like experts were used a lot. I could be wrong about that. I went on Westlaw, looked up New Mexico District Court, Court of Appeals cases, Supreme Court cases, typed in the keywords that if I had typed them in Minnesota, I would have gotten 50 plus cases, and I got like 2. And then I read them and they had nothing to do with what I'm talking about. So I don't know if this is all new or they just go to your district court and nobody ever appeals it. But I know a lot of times people think you would only want to call an expert if your victim was uncooperative. A lot of times people think, well, I just need to be able to explain why my victim's recanting. When she gets on the stand and says, no, it didn't happen, I lied, I was drunk, I'm mentally ill, I didn't take my meds that day, all the things I've heard, like the same story over and over again. Of course, you're going to want an expert to be able to explain the reasons why a victim in general would do that. But I also find it very useful. It's almost, this is, a lot of people don't believe me or understand this until they actually do it, but I find it harder to prosecute a domestic violence case when my victim is cooperative. When my victim is cooperative, my jury is looking at her like she's a liar. My jury is looking at her like, and I keep saying her, I understand men can be victims of domestic violence, but that's what the power and control wheel is for women that are victims. But they're looking at her like, what's her motive? Oh, does she just want a divorce? Does she just want custody of the kids? It is like Mean Girl the whole time. Like, why would she say this? Because a lot of it's he said, she said. That's when the jurors are like, this is he said, she said, you know, whatever. So I like to use an expert to explain all the things the defense is going to say about why she would delay the report, or if he really beat her, you know, strangled her last month, why is she still in the home? That makes no sense. Like, why would she do that? And that's some of the most helpful times to use an expert. But when I'm using an expert with a recanting victim, or a recanting victim trial in general, is usually way easier for me to prosecute. And I know sometimes prosecutors think, as soon as my victim recants, I'm done. There's nothing I can do about it. And I know this isn't a training on how to get in hearsay under the residual exception or excited utterance or confrontation clause. I could go on with prosecutors for hours about how to still get a victim's statement in, even if they're recanting substantively. But what I find is that the jurors look at it differently if the victim is willing to go up there and lie and say it didn't happen, especially if you have photos of, you know, injuries and corroborating evidence, of course. If you have an expert explaining, like, this happens, I mean, they don't usually give stats, but like 90% of the time, like, this is so common. It is so common when victims when they call the police, they're not calling to have their abuser prosecuted. They're calling because it's an emergency and they need help right then. And as soon as their abuser is arrested, or as soon as the criminal justice process starts, they have basically zero to gain by cooperating with that. Almost zero most of the time. And that's the sad fact for me as a prosecutor, is I have to remind myself, like, this criminal justice process doesn't always make that victim's life better. It does, in the sense that we're standing up to domestic violence. We don't believe it's okay as a state, as a prosecutor. We won't allow it, making sure the offender is being held accountable. But the criminal justice process is not entirely victim friendly. It's very much about defendant rights. It's very much about, do they want a speedy trial? They get to confront people. They have to, you know, it's everything about the defendant. And it shouldn't be shocking to anybody when your victim recants. I just wait for it. If it's not by the time we call her at in custodies to tell her about, we got the reports, here's the bail we're going to ask for. If she's not recanting by that point, I'm like, okay, let's see what we can do to, work through this. If she's then, usually it's a week later or the next week, because we have a no contact order in place and her utilities is cut off, and all of these things where nobody in this system should ever be shocked when the victim finds that it's more important to protect herself and do everything she can to not get beat again in the future, to show her abuser this isn't her fault. In Minnesota, at least, we always tell the victims, this is our decision. It's the state prosecuting your abuser. It is not you. It's not your choice. Once the police are involved and I have enough evidence, I'm prosecuting the case. So experts are needed or good in cases of recanting victims, usually easier to prosecute, and also for sure in the cases of cooperative victims, because sometimes people think, well, the victim can explain why she didn't report right away, especially like a really cooperative victim who has decided, I'm going to stand up, I'm going to say my truth, that they then I need an expert to be able to say, yes, that's accurate. She's not just, lying. Like, this is very common. And let's see. I always look at, what do I want to be able to say in my closing? So the expert witness cannot testify about, can't give an opinion in Minnesota, at least in this particular type of case. And when I've looked at other cases in other states and in federal court, I believe it's really all the same when it comes to this type of expert testimony. I know we're all used to expert testimony and DNA or blood spatter, where of course the expert gives an opinion. But the way the Minnesota case law is like, okay, well, we'll give you an expert. We'll let an expert explain general counterintuitive victim behavior, but we're not going to let that expert in a criminal case give an opinion about whether your victim is a victim of a battering or your defendant is a batterer. And so it's my job as a prosecutor to put the information together and tie it all together in my closing. So I'll have presented my case. I have the expert testify to generalities, and then in my closing, I'll put it together and explain why my victim is a victim of battering, why it makes sense that she got on the stand and lied, why it makes sense that she did this or X, Y, and Z, and how I've proven my case beyond a reasonable doubt. And the next slide, please. So I have this up here, and I know it's Minnesota law. The next slide, I have New Mexico rules of evidence, but in reality, our rules of evidence are the same, except for maybe the little bit different wording, because both Minnesota and New Mexico are clearly just modeled after the federal rules of evidence. So, Rule 702 is the main rule that you are going to go to regarding what you need to have an expert witness testify, if scientific, technical, or specialized knowledge will assist the trier of fact. And so I have bolded specialized knowledge because that's really the area that we're going to be talking about for a domestic violence expert. As Scott was saying, we're not going to be focused on scientific and research articles. It's really based on training and experience. And then just the general relevance rule about whether it's relevant and probative. So if you want to go to the next slide, you'll see the New Mexico. And I apologize if I got any of this wrong. I just went on Westlaw, found it. Hopefully it's right. But it appears to be modeled after the rules of federal procedure, like I said. So 702 about other specialized knowledge is in there for you guys, as well as your general relevance admissibility rule regarding whether it's relevant and probative value substantially outweighed. So our laws, rules of evidence are the exact same. I realize I may not mean that our case law is the same, our judges are the same, our understanding is the same. I don't pretend to know what it's like to practice in New Mexico or what you can or cannot convince your judges to do. I think the hope or point of maybe me presenting about this is just to think about it, do your own research, look at your own case law, see if you can blaze the trail, I guess, to have this type of testimony in your district court cases so that you can get to the point where you can convince your judges and then later your jurors that this is something that is normal for a victim to recant, or all the other behaviors that we've talked about. Good. Next slide. And if anybody has a question, I can only see, I can't see everybody, so if people are raising their hand, and I'm trying to see if these chats are questions, but if you do,
Mariel, we'll help you with
Okay.
with questions. So folks, if you have questions, either raise your Zoom hand or put it in chat, and we'll make sure that Mariel gets it.
You'll interject. Okay, perfect. I'm trying to do too many things at once. So please ask questions as I'm talking. I don't know how many prosecutors are on here or where everybody's from, but I would be happy to answer questions at any time. So when you're arguing for an expert, it's within the discretion of the court, and this pertains to any expert. So this isn't just domestic violence experts. So you could go and look at your case law about any type of expert, and you have case law in New Mexico about how you get an expert in, you have, the helpfulness requirement, are they an expert, and all of those things. It may not be the exact language that I have here, but I'm confident that New Mexico admits experts all the time. So the things that you need to look at is, will they be helpful, and are they in fact an expert? And so as I was kind of talking about before, when I'm arguing to a judge about why they would be helpful, we go to all the reasons about, well, the defense is going to argue X, Y, and Z. I know their case is going to be, well, especially if the victim's recanting, it's obvious, right? They're going to go up there and say, she said it didn't happen. It didn't happen. Like all the things that they're going to use. And so that's what I'll try and argue to my judge. Is there a question?
I'm going to say there is. Matt, I'm not sure if you're making a comment or if that's a question, but Matt's statement in there says, sounds like it's not about the law, it's about how others, parentheses, the jury, interprets domestic violence and the normalization of violence. Matt, do you want to add to that?
Look, a lot of this is new for me, and based on what you're saying, Mariel, the strategy of who I put on based on how others are going to interpret what they say and the assumptions that they make about the person who has been suffered from violence, it doesn't sound like it's really about the law, but correct me. I mean, it seems like how others interpret it, which goes into stigma and normalization of, well, why didn't you, and why didn't you, and why didn't you? That's interpretation. That's not the law, but that's just what I'm hearing.
Yeah, I mean, I would say I didn't look up, I guess, the domestic violence laws in New Mexico. I just assumed they're the same, that you can't hit your spouse, you can't assault them, you can't, whatever. So the law is the law, but when you're going to a jury trial, the jurors it's their job to be skeptical. I guess the defendant is innocent until proven guilty, and it's my job to prove it, but they will use almost anything, especially in what they think is a he said, she said, to say, well, I'm sure they're lying because of this, or I'm sure they're lying because of that, or people's just own beliefs that there are people who believe that if you get abused and you don't leave, it's your fault, or there are people who just want to believe, and maybe there are people who don't believe that. I mean, I think there are, but the burden of proof for beyond a reasonable doubt is so high that they'll just look at it in their life. I've heard many women say, if I were ever hit, I would leave. Like, duh. Like, if my husband ever hit me, done, divorce, whatever. And so if you have jurors, especially jurors who aren't familiar with domestic violence at all, except maybe in watching like SVU or something, I don't know, but like they're sitting there on the jury, this is not a frame of reference for them. If you have people in the domestic, it's like I can talk to, doing this work for so long, I can talk to people, my work people and Scott and, my other prosecutors, and it's like we have this whole different understanding, like language, and I'll go talk with, my family and friends who don't get it, even though they think it's just very difficult. So yes, it's not about the law. The law is always on my side, because I wouldn't be having a trial if I didn't think I could, the law applied, and the defense wouldn't let me go to a trial if I didn't have probable cause and all of that. It's just getting the jurors in the position to, really the whole point is to be able to allow them separately to assess the victim's credibility based on the information they have. And it is not general knowledge that victims would act in this way. And I was, looking, some of our judges do it too, it's everywhere. And I was reading some of the New Mexico case law, and there was a judge that was like, well, you and I, we all know that happens. We all know, whatever behavior it was. We don't need somebody to come in and tell the jurors that. And I would just say, BS, because if we all knew that, we wouldn't be here. Like, all the jurors don't know that. They just don't.
And Mariel, can I just jump in? Like,
Yes.
when you're choosing, when a jury is being selected, they're actually trying to select out anybody who might know anything about domestic violence.
Yeah,
And
the defense is.
Right, right.
Sure.
I mean, they don't want anybody who has any insight at all into domestic violence on the jury, right? So I had the opportunity to participate in federal military court. There doesn't seem to be a lot of rules. You can kind of do anything. So I was actually hired to be an expert witness, but I was also hired to be a consultant, and I got to help consult with the attorneys picking the jury, right? That I was going to testify before, which is, I would never get obviously to do in district court. And anything, one little statement that they would make that would give them any insight into the problem, out, right? So it's interesting that they say everybody knows it, but then they get rid of anybody who does. So it's just one of those burdens that make it difficult for the prosecution. Johnny, I see you got a question.
Yes, now that we're getting to a point where we're able to bring more experts in to testify in both the criminal case and in the order of protection, there seems to be a repeated process. It's called, in New Mexico, I'm sure you're aware of it, it's called voir dire. And it sometimes bringing in the new expert, and when they, can you talk, or Matt, is that still something that is done in Minnesota? It seems like every time you bring in a new person that's going to be offered as an expert witness, they go through the process of voir dire.
So that can mean a couple of things in Minnesota. So do you mean just like outside the presence of the jury, you talk to them, they testify in front of the judge, where you try and get out their qualifications and their expertise, the defense cross-examines them, and then the judge decides if they're an expert? Is that what you're talking about?
Yes, and then once they're deemed an expert, I think they remain an expert in trials after that. But there's that first initial, and it kind of, you know, one of the cases where there was a jury, when they talked about it, the jury was excused, and then they went into voir dire, and then there was this long process, and it was, I think the defense's, you know, attempt to remove, they know that that person was going to offer testimony that would, you know, pretty much slam the door on their client, so they didn't want them in. So they're, you know, that was something that we are seeing more frequent now.
Sure. So I think it depends in Minnesota, at least, on the judge and their, you know, Scott can maybe speak more how often he's, excuse me, how often he's had to testify outside the presence of the jury just regarding his qualifications alone. We've been, so my county specifically has been calling an expert witness in a lot of cases since probably 2007, 2006, 2007. And we have been calling for the vast majority of it, Scott specifically, or Melissa Skaya, who's somebody else he's talked about. So in the beginning, we had more challenges to their expertise that were entertained by the judges because they didn't know them, and they had to, you know, they had to convince the judges in our district, in our county, that they were experts. And so yes, there were definitely times early on that they were questioned outside the presence of the jury about their expertise. I would say now, because it's so many years later, I mean, we've had new judges since then, but they know their coworker has allowed the testimony in, they've seen him testify, they've heard about it. And so now the defense still objects to it, don't get me wrong, like they still, and sometimes they usually now object to Melissa or Scott based on, you know, they're not relevant, it's not helpful in this case, and all the things that a defense attorney is going to say. They don't usually object based on expertise. Some of the private defense attorneys who don't know, haven't, you know, had them before might. And our judges aren't, they're basically, they've seen them, they've, you know, Melissa and Scott both have lists of cases they've already testified in where they've been deemed an expert. And so they don't really, they just discount it. You know, they say they're an expert. That doesn't mean that when they testify in the stand, that the defense still gets to cross-examine them and make them act as if they're not an expert or they don't know what they're talking about. I don't know how many times Scott's been cross-examined on what his bachelor's degree is in and why he doesn't have a master's degree in domestic violence, right, Scott?
Right. I mean, well, that's every single time. But
Yes.
one of the things about having to, you know, demonstrate your expertise outside the jury that I don't think the defense thinks through is that in that hearing outside the jury, I get to know most of the questions that the defense are going to ask. So now I get a way to prep, right? So now when I get in front of the actual jury, I know the sequence of questions that the defense is going to ask, and I've already had a run at it once. So I actually don't mind that. I don't get to do it very often, but I don't. It's from my perspective, it's okay. And so I remember a challenge in Duluth where to go into what Muriel said about the judge's knowledge, the defense attorney said it was a misdemeanor case. In Minnesota, there is some disclosure of witness rules around felonies that aren't in misdemeanors. And he felt like he didn't have enough time to research who Y was. And the judge said, it would take you one phone call in Duluth to find out who Mr. Miller is and the work he's done. So, you know, he just rejected the argument. So again, a lot of it depends on if the judges know you, if they don't know you. how laborious that process might be to get to in front of the jury. But it's not a bad thing for an expert to have a run at the defense's questions beforehand. So, yeah.
So I see, one of the comments is the challenge in New Mexico is prosecutors rarely call experts. They rarely fully prosecute a case to completion. So the only, thing that I'll say to that, I guess, is calling experts in Minnesota. I wouldn't say it's newer anymore, but it definitely wasn't around prior to 2006, 2007, 2008. And it took a lot of work to get there. When we started calling them, my county, Stearns County, has a lot of the case law at the Court of Appeals. And this, probably, I don't know if there's any Supreme Court cases, because we just started calling them a lot. We're not the only county, but a lot of them will be from our county. And it was a lot of work. Every time I wanted to call one, I would write a full brief on it. Now, once you've written one, there is some copying and pasting. The law is the same, but then putting the facts of my case in, really, really, really pushing for it. And it wasn't easy. It wasn't like one judge right away. It wasn't like everybody was super open to it. The defense was very against it. There was some case law on it, but not a ton. Now, in 2021, if you go on Westlaw and look at our case law, a ton of it is unpublished because it's so not important. I mean, I don't mean important, but it's not like groundbreaking law that we would be able to have an expert come in and testify about counterintuitive victim behaviors and battering and things like that. And so some of it, or a lot of it, is just, a paradigm shift. I have, trained on this in Minnesota multiple times with other counties, with our County Attorneys Association. And even though I think we have a very good case law on prosecuting domestic violence cases regarding a lot of different issues that aren't just this, it is, it's a lot of work. It takes a lot of time, and there are many prosecutors in Minnesota, much smaller counties, that don't have the time or resources to do this. They feel like their county attorney, i.e. district attorney, won't pay for an expert to come. And it's still something that I'm trying, and Scott and Melissa, and trying to explain, it actually doesn't cost that much money. And actually, if you get an expert, if the judge says you get to have an expert, you're more likely to resolve your cases. I can't tell you how many jail phone calls we listen to where the defendant's like, oh man, my attorney tells me they're going to bring in this person to basically say a bunch of bad stuff about me and explain why my girl's not coming or whatever. And, so many cases resolve because of that. And my advice or hope would be that people just take in what they're hearing today and try, and you're going to fail. You're not going to convince if you've never had it in your district, and maybe you have, it's going to be really hard to convince your first judge to do it. But that's when I wouldn't do it until I have the time, and nobody has time right now. I don't know what the backlog from COVID is like in New Mexico, but we are swamped. And so I know people in general don't have a lot of time. But if I were in New Mexico and wanted to do this, I would go through the case law. There's not a lot that I found. I would go through your Court of Appeals cases. I even tried looking in the 10th district, where I think you guys are, to see if there was federal case law on it. There is just not a lot for you guys. It seems like it will be an uphill battle. It will be an uphill battle that is worth taking, but I don't pretend to sit here with my awesome case law and my ability to get this stuff in and pretend like I know what it's going to be like for your prosecutors to have to do that.
Say, Mario?
Yeah.
You touched on this, and I think this is important for folks to know, that when you go through the hard part of establishing expert witnesses in domestic violence cases and you start having success, right? Because it's going to be a lot easier get a conviction when you have an expert, that you can draw from. Then the defense learns that if there's an expert called, to your point, it's going to be a lot harder for them to defend their client, and then you get better plea deals than you would if you didn't have it. So just to let you know, every single month of the calendar year, I have dates where I am holding my time for expert testimony. I might actually only testify 4 times a year. I'm probably called 30 or 40 times a year. But most of those cases, because I'm called as an expert, they see the resume, they see the how many times I've testified as an expert. They realize I'm going to get in, and then they go back to their client and say, this is what you're up against. That's what you can end up creating. So although it might be difficult up front, there is definitely return on the investment once you establish that practice in your jurisdiction.
Yeah, absolutely. Once you convince your first judge or your second judge, or it becomes normal practice and your defense attorneys see how that works out. I mean, domestic violence cases are, I've said this before and I can't say it enough as a prosecutor, are so hard to take to trial. And I would never discount that. But the vast majority of ones that we take to trial and have an expert in, we win. Can I say everyone? No, because that would be ridiculous. It would mean we're only taking like the best cases ever to trial. I mean, my office tries a lot of domestic violence cases. We are not an office that we don't dismiss a case if the victim recants. We don't dismiss a case if the victim doesn't want us to. We very much take the approach that is, some people may disagree with, but that it's our job to prosecute this case to the fullest that we believe happened. Like, we ethically believe this person assaulted their victim, and there are times we can't, you can't, everybody knows about the confrontation clause, and there's only certain things you can get in. If your victim doesn't show, if she doesn't show, you can only get in non-testimonial statements, maybe your 911 call, etc. And so if we can't find a victim, we try very, very hard, we subpoena them. It's not to say my office doesn't ever dismiss domestic violence cases, but it is the last resort. We spend a significant amount of time and resources trying to prosecute every case, misdemeanor level up to felony. And a lot of that is, I can, credit my county attorney who's been there for many years, who is willing to allow us to use those resources, take the time, have the money if we need to call the expert witness. But yeah, I don't know if I'm still answering the question anymore.
One more thing, Mariel. So we've been talking about this 3-legged stool, right? So the practice of using expert witnesses as an intervention within a coordinated community response meets those 3-legged stool, right? So it makes it safer for victims because there's a way now to take control of the offender. They're not just free to go. They're not just free to walk the earth the way that they want. There are going to be some controls put on that individual if they are convicted of a domestic assault. So there's a way to make it safer for her. There's a way to hold him accountable, but it also makes the job experience of the practitioner better. So the prosecutor then isn't going to go to trial as much once they've established use of expert witnesses, because they're going to get good plea deals in most of their cases, right? That helps them because you can't try every single case. Most of these are going to plea out. The question is, what kind of plea are you going to get? What kind of leverage do you have to get a plea? And an expert witness increases the leverage significantly in these cases. Therefore, it makes it better for the prosecutor, right? So again, we're always thinking, how can we develop interventions that make it safer, easier to hold accountable, and better for the practitioner? And this is an example of that once you establish use of it in your jurisdictions.
Yes, I would agree with that. And, in Minnesota, if you're convicted of domestic violence or an offense arising out of it, by statute, you're required to do the 24-week, 36 hours domestic abuse programming that I'm guessing Scott has already talked about, the batterers programs. And so that is a huge incentive to try and get a batterer convicted. so that they are required to do that. And, when I said before, the victim's life isn't going to get any better from the conviction, I guess that may not necessarily be true. I just try, and I see so many victims that struggle through the process, and I know it's a horrible process for them. I wish it was better. It makes me sad. But I also know that it's the best and the right thing to do is hold an offender accountable while still looking out for victim safety. And that is accomplished in a certain sense when they're convicted. They have to do the programming. Hopefully they learn something from that. Hopefully they get better. I'm a little more of a pessimist about that than Scott and Melissa are about people changing, but I don't think it hurts to try, and it can only help out that victim or a potential future victim. So the next slide, please.
Before you do that, Meryl, we have a follow-up question from Johnny. Are you using experts in pretrial detention hearings?
So I don't know for sure what a pretrial detention hearing means, other than they were maybe just arrested and bail hearing. Is that what we're talking about? Every state's different.
Johnny?
In New Mexico, if an individual's arrested for a domestic violence charge and he's looking to make bail or has made bail, the district attorney is alerted, and a lot of times they will ask the court, because we have a catch and release program, and the legislature has put some laws into place that get the guy out real quick. And if you're going to keep him in, the state has to go before the district judge, and even if he hasn't made bail, he still has to go before the court and say he poses a danger. So okay, those assessments that he's going to use, a lot of times it's an ODARA in our case, in our area. So they will ask for an expert witness to come in and testify as to his lethality, what type of person or what type of threat he poses to the community or to the individual. So we're seeing, and the success that they've had is when they brought somebody who's an expert that can testify as to an assessment or an evaluation of, his prior conduct. So
okay, I understand your question.
We are starting to see that.
Okay. So no, I've never done that in Minnesota for our domestic violence cases. I think most jurisdictions have them as a mandatory arrest. It's not a mandatory arrest by statute necessarily, but most have them, their officers' policies are mandatory arrest and then a mandatory hold for court. And so our individuals have to be seen in court in front of a judge, no matter what, within 36 hours, which doesn't include the day they're arrested and, whatever. So we're always doing bail hearings. And no, I've never had an expert testify. Honestly, our judges have heard us, me and the other domestic violence unit judges or attorneys handle those files. And they've heard us argue all the things I've just kind of talked about so many times that I think most of our judges understand it. So when somebody's arrested, our victim witness coordinator person, I guess, that from in my office, will contact the victim and do a full danger assessment with them, the Jacqueline Campbell danger assessment. On scene, our law enforcement does a lethality assessment, which is a little less than the danger assessment questions and whatever. And then we also, our probation or pretrial services does a statewide bail study where it's not as intense as what that would happen if they were sentenced and the risk factors, but they have a certain amount of questions they ask. So just we as prosecutors will argue lethality concerns, or the bail, the bail study came back putting him at medium risk of a reoffense, high risk. The lethality assessment came back, or the danger assessment puts this victim in extreme danger of being murdered by her partner. And then we'll add all the different things that we know of about their prior criminal history. If the victim's uncooperative and we don't believe the danger assessment is therefore valid because they wouldn't answer questions, or maybe they minimized or lied about things that we know are lies based on previous police reports, previous interactions, maybe even what they said on scene, because we all know what they say on scene can change even 2 days later. And so I guess we find success in just as us as the prosecutors relaying all that information to our judges. One of the things talks about the difference between anger management and domestic battering. Hope I didn't say anger management. They're definitely different. Anger management and domestic batterers intervention programs. They're two very, very different things. I think that when I started prosecuting in 2007, 2008, we were sending our domestic abusers to anger management. That was just what our judges did. That's what people called it. And we haven't done that for years because it's not about an anger problem. It's many, many, many other things other than that. So I know here on the screen, I have a lot of Minnesota case law, and I would have found your own case law if I could have found any. So I just kept it on here because I've presented about this in Minnesota before, just to give you an example of some of the cases. This is just a small snippet, of some of the cases that allow expert testimony for counterintuitive victim behavior. So though there is a Supreme Court case from 1997 that was kind of the start of it all, but more of the recent stuff of what I'm talking about happened more in like 2007, 8, 9, continuing on till today, because the defendant's still gonna appeal, and they're almost always gonna bring that up as an issue, like there shouldn't have been an expert. But I've never, and I say never use never, but I haven't found a case where our Court of Appeals said it was an abuse of discretion for the district court to do that. So the next slide. This is just an example. This is very simplistic version of like a notice I'll give. Usually I do my motions that are a bunch of different other things. Here's how I'm going to get my victim statement in. Here's why this is an excited utterance or a residual exception or medical records or anything and everything to try and prove my case. And then I'll notice just briefly an expert. And at this time, I don't usually know who it's going to be, who's going to be available, and things like that. So it's pretty general. And like I had said in the beginning, and if we get a new judge, I will still do this. I would write a full brief explaining everything and why it's appropriate. Now our judges are just they know the law. Like they all know the law. They all generally will say at a motion hearing to the defense attorney, Mr. So-and-so or Miss So-and-so, as you know, I normally allow this in, like explain to me why it wouldn't be appropriate here or something like that. So I know that it's gotten way easier for us. But in the beginning, I would spend a significant amount of time writing a brief and trying to convince my judge of this. Next one, please. So common defense objections, if you're doing a pretrial hearing on this, is that it would be improper bolstering. And this would be more like you're trying to vouch for the credibility of your victim. You're trying to say, my victim's telling the truth because this expert says so. And this kind of goes along with legal conclusion. So my response to that, and I've already touched on this, is that the expert is not allowed to talk about your victim or your defendant or give an opinion on either of them, whether your defendant's a batterer or your victim is a victim of battering. And so that's pretty easy to explain to the judge, who, once again, our judges understand that they're not bolstering, improper bolstering. It's like in my closing, I can talk about all the reasons why it would make sense based on what we know, why my victim would recant, why my victim would delay reporting, stay in an abusive relationship, all of those types of things. And it's not improper because the defense will get to argue, no, they did that because they wanted the kids in the child custody dispute, or they did that because they were going to be homeless, or they did that because they were drunk or whatever. And it just allows both sides fairly to give a context to the jury to make their own decisions. So there's nothing improper about that, and your expert's not giving a legal conclusion. And same as whether it's prejudicial, and then this is the jury's already knowledgeable. We have a lot of case law that says they're not. That helps us. I mean, I know that case is from 1989, but it just continues on over and over again that obviously jurors are not knowledgeable on the subject matter. and then that they're not qualified. And that kind of goes to the other question of, are you doing hearings ahead of time for the judge to decide that? And I think if you brought a brand new expert that nobody knew anything about, that would probably be an appropriate response for your judge to do, or even you to offer it. Because sometimes as a prosecutor, yeah, you might be able to look at a resume or CV, but you may not be able to explain as well why your expert's qualified. And as Scott said, sometimes it's better to be able to do that. The thing that kind of is not awesome about that is, one, if they make you do it ahead of time before trial, like weeks before trial, then you're paying your expert to come and testify, which is, time out of their day, money for you and your county or your district attorney's office. Or sometimes the judges will do it, the morning of trial or the day of trial, which also isn't awesome, because then you don't know for sure if it's coming in or not. Then you don't know how to do your opening or exactly how your case is going to come in. And so it's, I guess, pros and cons to both ways.
Say, Mariel, just given the time that's left, I'm wondering if you could jump to slide 12. Battered Women Syndrome, I've given them an article on the problems with that, and we can talk through that, but I know you've got about 10 minutes left, and who should be a witness and how you want to use them. I think that'd be an important thing to have before you leave.
Perfect. Yep. No problem. Okay, because we use Scott and Melissa, they are or have at least been at some point in time advocates. They both have a lot more experience in various, other areas, but you can use anybody as long as they have the specialized knowledge. You need to convince your judge they have the specialized knowledge, but it doesn't take a particular degree. It doesn't take it, well, you must have gone to college. You have to have your BA, or you have to have your master's or your PhD or anything like that. None of that is a requirement anyway. You could have an advocate who's worked at your local shelter for 20 years and has specialized knowledge. Now, that being said, you generally aren't going to want to use your local advocate, because especially if you live in a smaller community, because you're not going to want, you may run into issues of conflict of whether they know these people. And two, sometimes your local advocates aren't going to want to be seen as being against, a victim, especially if that victim is recanting, or they wouldn't want it to get out in their small community that they're helping the prosecution when the victim doesn't want it. And so sometimes, even if you just get a local advocate, a county down, or, I don't know, where they aren't as much a part of your organization. And then police officers are an option as well if they have that specialized knowledge. Once again, I wouldn't use the officer from your case, because they could be seen as biased. Really, they shouldn't know the facts of your case. They are supposed to be just giving general knowledge and information. And so if you have a great police officer that does domestic violence cases, awesome, and they really understand it, and they're really good with victims because they know they recant and they know all those things, that could be an option as well. So you can go to the next one. Scott already, I heard him talk about this before I came on. They want very limited information about the case. And it's not like a rule in Minnesota or case law that they can't know the facts of your case. They just can't testify about them. So it's way more powerful for me to go through all of their testimony and then at the end say, do you know victim? No. Do you know defendant? Nope. Do you know any facts of this case? No. Have I provided you any reports about this? No, you have not. Well, that just takes away every argument from the defense that they're biased or they tailor their testimony in any way, because they literally know nothing about my case. Yet when I go to closing, I'll explain, well, isn't it interesting that they knew nothing about my case, but they were able, to explain this, why my victim would do this, why my victim would do that, etc. Next one.
Say, Muriel?
Yes.
I would give an example of that. So I sent Teresa a transcript of my first trial that I testified in, because I want to get a transcript of the first trial. So trying to prep and be good at this work, right? But anyway, in that particular trial, I was asked about the tactic of emotional abuse. I kind of gave a brief explanation of what it is. And then the prosecutor said, is name calling a part of emotional abuse? I said, it is. What kinds of names do you tend to hear from the abusers you work with in regards to this tactic? And I said, well, it really comes down, cunt, whore, and bitch tend to be the names that he ends up calling, because he knows those particular names are the ones that hurt the most. And he's trying to inflict harm with his words. And so, anyway, however I explain that, what I did not know is that the prosecutor had a videotape of his arrest. And as they were taking him out of the house, he said, she's a cunt, she's a whore, and she's a bitch, actually in the exact same order that I had said it, right? And this is a guy who was never convicted up to that point. They had been arrested multiple times. She'd always recanted, and he'd always been acquitted. The jury was out on that case for about not even 10 minutes and came back with a guilty verdict, because my testimony mirrored what the hard evidence, and I knew none of it, right? So that's the power that Muriel was talking about. When I'm answering questions that I don't know any of the facts of the case, then how does this person who doesn't know any facts of the case so ground this the evidence in the experience of the victim, right? That's why it's compelling. So
Yeah, if you want to go to slide 20, since we are running out of time, so I'll just give some kind of examples of in my closings. But before I do that, I just remembered, so when the judge is saying, the defense attorney is saying, well, everybody knows the subject matter and no, we don't need this. I was going to give an example of how that's not true in a lot of ways. So I had me and a coworker had an attempted murder trial this year of intimate partner violence, where he stabbed her a bunch of times, and a pretty terrible case. And the victim was cooperative, but she had been in that abusive relationship for many years, and it was less physical. It was very many things in the power and control wheel, a lot of controlling behavior, stalkerish type behavior, emotional abuse, and things like that. But they had 5 kids together, and 2 of them were adult children, and 3 of them were younger, and they were in the home when this happened. But the 2 adult children weren't in the home, so they sat through the whole trial. The other children couldn't, and probably shouldn't have, because they were witnesses. And the 2 adult children, 19, 20, 21, we had Melissa Skaya testify in that case to explain, because we were allowed to bring in evidence how he had abused her before, which once again, the physical abuse wasn't that much, but some of the stuff about stalking her, going to her work, and things like that. The 2 adult children, when Melissa was testifying, started bawling, like listening to what she was saying about why victims stay in relationships, what emotional abuse is, intimidation, using the children. And when they left and the trial was over, they told their mom, like, we never knew what you were going through. And they were in the home and they saw a lot of it, but they never understood what was happening or what their mom was going through, because she hid a lot of it. They all knew dad was kind of crazy and, needed to know where mom was at all times. And they knew it wasn't good. Like, they knew it wasn't a good relationship in that sense, but they never, understood. And the funny, or not funny, but interesting thing about that story is our victim in that case, who didn't know the expert, reached out to her, and now they're presenting together on things and whatever. So it's like, even family members don't understand this. So how could you expect the general public to understand it? But so here's just an example I pulled from one of my PowerPoint closings of how I'll put things together. This victim recanted, minimized on the stand, didn't happen, but there'd been a long history of abuse and they had a child together. So I'll take the power and control wheel, and the things that you see next to it are things that came in at trial, whether it was the victim's substantive statement that came in, whether the defendant said it, whether the child, in this case, I had the 8-year-old testify it was a burglary with an assault. And I had some text messages. So some of these quotes are from text messages. Some of them are from things the victim admitted to, but didn't really know that she was helping me. So some of the emotional abuse and things like that. And so this is just an example of how I would put things together and explain to a jury. And then the next slide is just another example. You know, in every case, you're not going to have every single thing in the power and control wheel, whether it exists or doesn't exist, especially if they're uncooperative. You're not always going to be able to get it into evidence, what you know to be true, because the rules of evidence still apply on how you can get things in. But this one was a defense attorney who was the abuser, and it was a pretty relatively minimal assault and fear assault, and that I was successful on in explaining why my victim would recant and why she was afraid of him and wouldn't go to police. So I can be done unless there's questions.
Yeah, so just the power of the testimony, right? I was testifying in a very northern county in Minnesota, and the jury pool in that particular trial, they could only find 2 people who had not grown up with domestic violence in the entire jury pool. So most of the jurors had experience personally with domestic violence. As I was testifying about what makes it difficult for a woman who's got older children to leave an abusive relationship, one of the jurors gasped. You heard an audible, right? And so when I asked the victim witness coordinator after the trial if she had any insight as to what that was about, after the trial, she had talked to the juror, and she said, this was the first time I understood why my mom never left my dad. As kids, we judged her so harshly for not ever leaving him because he was so abusive, but we never understood why it was so hard for her. Today, I learned that. Another trial I was in, the brother of the defendant came over to the prosecutor after he was like in his 40s, came to the prosecutor after the trial and said, I just learned a whole lot about my life that I didn't know by listening to your expert talk about this problem, right? So, I mean, that's the compelling nature of it. And if it's compelling to the people who experienced it, it is to the jury. Now, one thing I would say as an expert witness that helps me is that I'm used to training. I'm used to taking a complex thing and reducing it down to kind of a simple explanation. And that's depending upon the defense attorney. They might not let you talk very long. So you don't get to have these long stories about domestic violence and everything that's going on. So you've got to find a way to kind of hone your testimony down and be able to present to the jury and look back at the prosecutor, and present to the jury and look back at the prosecutor, right? Because they're the ones who are the fact finders. They're trying to figure out whether or not the things that I'm talking about relate to the case that they're making decisions on, right? And so the more clear I can be, the less confusing the less confusion the defense attorney is going to be able to create with my testimony, right? So questions, thoughts, comments. Can you imagine yourself in this role? Your community needs you. Your prosecutors need you. Virtually anybody on this call, given your experience, is an expert. You'd be qualified. The question is, do you want to do it? And what questions do you have when you have somebody who can answer them on the call? What questions do you have about doing this kind of work?
I have a question. This is Sherry from Mexican Asian Family Center, if that's possible. I know that sometimes the hard part is also trying to prepare. In our agency, we help our communities that have language barriers and have issues with those kind of things. And the intimidation of what the court setting is like already as it is, not that the court intends it to be that way, it's just intimidating. And even though it's not in the power of will, that is common for us, immigration and deportation is one of the biggest things that can be used against our victims and our survivors. That's something that sometimes can be held as a issue. So when we're preparing our victims, our people to be able to be prepared and be able to say it in the language that is understandable for jurors to understand what kind of abuse they've been through, and just to even honor their wishes to where they're at. Is it harder for us to even, I don't know, like, is there a way that you've worked with people with cultural barriers that have been helpful to you as a prosecutor, that's or as a witness as well, or a professional in your level?
I'm not 100% sure I understand your question. If you're talking about, you or someone testifying as an expert, or are you just commenting on how much harder it is for a victim who has potential immigration issues in
Yes,
working
ma'am.
with that? Okay, the second part?
Yes, ma'am. This is
Okay.
more as like the idea that it's a domestic matters and domestic violence as a case of misdemeanor felony in a state level, as opposed to it's not a federal deportation proceeding. So trying to get through that in a court proceeding, and just even trying to prepare a client. We're not legal advisors, obviously, so we don't want to prepare them in a way that, but we want to be able to help them prepare in a court proceeding to make sure that they understand also what the law is and what laws that can help protect them.
Sure, and I don't know that I'm going to answer your question on point, because I don't, being a prosecutor, I don't know the immigration laws and things like that either. However, we do have plenty of victims in my county that are not here legally and have a lot of concerns about that. And so, one, what I try and do is advise them. We have a really good relationship with our legal aid department, our attorneys, who will have a special attorney that works with victims of domestic violence and sexual assault. And so we refer them, to attorneys who are, that's their job, to answer questions about, immigration and things like that. And in preparing a victim to come in and testify and go to the, be in court, which would be very intimidating if one, it's not your first language. You have an interpreter, you're afraid that maybe somebody's just going to take you and you don't know what's going on. Like, I don't have an awesome answer for that, other than I understand that that's a real barrier, and try and do wraparound services through our legal aid and through the advocacy programs, let them know that, that's not what, we are here to do. We've had had experts testify in those types of cases about, although it's not specifically on the power and control wheel about immigration consequences or fear of that, it certainly falls within that. And that's added barrier. We've had a lot of trials where, the defense will say, well, she just is saying this happened because she's here illegally and she just wants, a U visa, or she wants, whatever. And so we'll definitely use expert testimony in those types of cases to kind of flip the script and say, this is exactly why this victim is more vulnerable, and exactly why it was hard to go to the police, or especially if they're recanting, like what's in it for them, and all those things. So I don't know if I fully answered your question, but it is an issue.
Well, the other thing, Sherry, look at all the knowledge you have working with all those women who've experienced that, have gone through that. For you to be an expert and be able to put, because their testimony might not be stellar, right? Just given the language barriers, given their the intimidating nature of the space, all of that. So their testimony might not be great, but if they're recanting, or if there's counterintuitive kinds of elements to the case, you could come in and give context to that, right? Because this is your work, right? You know what the space, in general what women are experiencing going through that space, and you can give context to the jury about that experience. So then they understand why it was difficult for her to do this, or why she might be reluctant to tell the truth, right? All of that is there because they have you to be able to explain it, right? Yeah.
Thank you for that affirmation and acknowledgement. We really do need it in our community too.
And there's a thing with, I know this whole thing about I can't give legal advice. advice is one thing, information is another, right? Like, yeah, I can't advise you as what you should do, but I can tell you what the rules are, what's going to happen in general if you go through this, right? Because there's some predictability to the process. I can tell you that so you have some informed decision about what it's going to look like when I walk into that space, right? That's not advice, that's just information, right? So we got to be clear on what advice is and what information is. Matt.
Well, Scott, and that's the same line that we balance every day in health promotion about I cannot advocate for certain policies when there's something up for legislature, but it is my job to educate. I can educate about any health topic around and why certain things are healthier or not advocating for a certain policy, but absolutely education of
Right.
why this harms your health or why it helps your health, for
Right.
sure.
Yep.
One thing, as you're talking about, of that kind of getting my mind triggered, that although I'm not in courtroom daily, the collective impact effort that I'm a part of and the communication work that we're brainstorming about, how do we get the information when those people are signed and saying, I never understood until, how do we get that knowledge out into society more than just in the courtroom? So that people don't have to have those eye awakenings in the courtroom, but can have it out in life to go, that's what I'm going through. You need to get that information out there somehow.
Let's pick that up after the break, Matt. So we got Muriel here, but that's a more of a public education kind of question. So let's get to it. It's logged in my head. We'll come back to it.
I thought of one thing, and no, this isn't immigration consequence, like when we're talking about that, as a prosecutor, I can't tell you how many victims have come to me and said they lied and said, charged me with false name or false information to a peace officer, charged me with false report, like I lied, expecting that to happen. And sadly, I've seen that happen in other counties. I've seen sometimes our officers actually issue the citation. We then get rid of it. And I just tell them, you didn't lie to police. I know you didn't lie. I'm not charging you. You will never, immunity, you will never be charged with that. And when they, talk about going on the stand to testify, of course, I never say it's okay for them to perjure themselves. But what I'll say is, because I know they're going to get up there and lie. They have to, for whatever reason in their world, they have to. And I'll just say, I'll do my job. You do what you're going to do. You'll be put under oath, not threat. It's like I just want them there. I just want them on the stand. So I am not trying to discourage them from not being on the stand, because I have so many ways I can get in the evidence as long as they're there and I don't have a confrontation clause issue. So I say, I'm not charging you with anything. I believe what happened is what you told the police or whatever. Like, that's why I'm moving forward. I need to explain that to you. If you're wondering why I'm not dismissing the case, I don't believe you. I understand there's a lot of reasons you would be doing the things you're doing. I'll do my job. You do what you think you have to do, and we'll go from there.
Right. So that's an important point for us outside of the legal system to understand, is that there's all kinds of evidence that won't come in if she's not present in the courtroom. So even if she's present and recanting, that allows Muriel to get all kinds of stuff in that she wouldn't be able to get in otherwise. So that's why it's important to have her in the room, right? Yeah.
Can I also just add, I apologize. I know that you mentioned this already, and I know that there's a lot of reliance on the police officer to be able to do the due diligence, to be able to do the reporting, to be able to have all of those things in place. For someone who has language barriers and issues and cultural issues, and if I'm not saying all officers do, but some officers who come in with the lens of a bias already may not be able to gather that information. So how do you go around that with reporting? And that's what's being presented in court. And then you're relying on your interpreter to also tell the officer on what you are able to do. And I'm just going to set an example. And please, it's nothing against law enforcement or anything like that. It's just the fact that, like, one time the Dari speaking community member that we have is also the abuser, and then the one that's relating the information to the officer who's presenting this to the court, who's going to go through legal documentation for the victim. And it's not fair for that victim to continue to not only be perpetuated by the abuser, but the system that she's having to rely to do their due diligence without that bias. And I'm sorry, I feel like just.
Yeah. So one of the things, just Sherry, that the Duluth Police have as an administrative tool, right? What's the tools that we're going to give them to do their job? They have a number that is a statewide number for translators. If they come to a victim or a suspect who cannot speak the English language, then they can call that number, which is in a cheat sheet in their pocket, and get an interpreter on the phone, right? So, but they wouldn't, I mean, that's something you have to organize with the law enforcement as part of your CCR, right? That they should have the tools to do the job. If they don't have the tools to do the job, they won't do it, right? So we can blame the officers for not doing it, or we can give them the tools to do the job we're asking them to do, right? So yeah, that's just part of our work as organizers, to figure out if that's a barrier, then how do we solve it? And there's a way to do it, right? Does that help, Sherry?
No, and by no means I'm trying to blame an officer or anything like that. I'm just thinking of systemic concerns that we could definitely bridge with our community partners to be able to help our people, because that's who really needs the voice, and especially in court, especially in systems, especially in legal work, that's not their world. The world that they live in is in the community, in the spaces, the family that they have to go home to, the safety of their children and themselves.
Yeah, yeah. Anybody else have a question or a thought or a comment that you'd like to ask Muriel before she leaves? I'll just say one thing, Muriel, you can jump in on this, but one of the surprising pieces for me as an expert witness is that I went into these, I know that the defense is going to come after me. They're going to try and make me look not credible or confused, whatever, right? They're going to do that stuff. I thought they would be a lot more prepared than they ever are to challenge me. In fact, Ellen Pence, who is my mentor in this work, changed the way the world responds to domestic violence, right? Has this big influence. I said, Ellen, haven't you ever testified as an expert witness? Why haven't you ever done this work before? And she said, you know, I got this PhD in sociology, and I just feel like I'm going to get up on the stand and I'm going to get a question about Emil Durkheim that I can't answer, and I'm going to look like a fool. And I said, trust me, you will never be asked about Emil Durkheim on the stand. It's not going to come up because they really don't know how to deal with what I know. And it's very hard for the defense. They try, but it's very hard for them to find those kind of conflicts. Muriel, want to jump in on just from your perspective on that?
Yeah, I would say defense attorneys don't know what to do. And I think the hardest part for them in not knowing what to do is that you aren't talking about their client yet. You know, like, you're not at all. And so they, sometimes they'll ask questions. The biggest thing they'll focus on is like, how much are you getting paid? Like, lately their thing is, because we use experts, I'm telling you, like, a lot. And with COVID backlog, we're having more trials than we've ever had before, like in a row, like just nonstop. And it's like, well, didn't you just testify last week for the Stearns County Attorney's Office? So they're just trying to get a bias that they just say what we want them to say, and all of those things. But it's, my redirect is very little. And sometimes, depending on the defense attorney, I can see Scott or Melissa get a little more worked up. Not, just like I can tell because I know them that they're getting annoyed, and they're maybe they think the defense made a point that I know they didn't make, because most of it just is really ridiculous. And so I might ask a few questions, but pretty much every time they haven't gotten anywhere. This last a couple of weeks ago, Melissa testified, and the defense attorney the jurors were rolling their eyes at the defense attorney when she was asking a bunch of questions, because she was just going after her for not having enough things on her CV of like all the time she's testified or something like that. And we could see that the jurors were just like thinking this was ineffective and not helpful. But the defense, and my coworker won that case, but the defense attorney, I think, really thought she did a good job, because all of a sudden yesterday, my coworker's like, did you order a transcript of Melissa's testimony from that trial a couple weeks ago? And I'm like, no, like, why would I do that? Well, the defense attorney must have ordered it. And then we automatically get a copy. So I'm like, she must have really thought she did some good cross-examination on something that was terrible. So no, they're not good at it.
So here's the other thing too, is that I had to learn coming in, is that the defense would ask me a question, but they'll ask me a yes or no question. And sometimes I'll say, it's not really a yes or no question. I can't answer it that framed the way that you've presented it. Now I could be compelled to do it, but I'll start there, right? And because there's more that I know what they're doing with whatever the subject is. But what I didn't know when I started this is that the prosecutor is more attuned to what the jury's doing with what the defense attorney is asking. And so I might think you really need to redirect with me and we got to clean this up, but they're thinking, no, they are going down a road that is not helpful to them or their client, and I'm just going to let them walk down that road, right? So you really are putting your trust into that prosecutor as an expert witness to know how to go about it. I remember one trial, the judge looked at Muriel like this eye look, like, are you going to object to what's happening right now? And Muriel's like, no, I'm going to let this happen, right? And it was making me hot under the collar because I was, but it was actually advancing in Muriel's prosecution. So I appreciate you coming in, Muriel, for letting us kind of know what the landscape is. Give us an example of a particular intervention that you can create within your CCR to deal with the complexity and the difficulty in holding offenders accountable for domestic assault. So thank you so much, Muriel.
Yep.
And
Thank you for having me.
I hope this is the highlight of your day.
It probably is. Now I'm off to Zoom court, so.
Yeah, right. Okay. All right. Thank you.
Thank you.
Everyone, we are now on break. Let's take our 15-minute. We'll put up a counter and we'll come back. Teresa, did you get all the documents that I sent to you?
Yes.
Okay, cool. All right. So I ended up inadvertently sending it before I was done because I was panicking trying to get it done and listen to what the presentation was doing. But there's a whole bunch of documents that I sent around that I either use, that I send to prosecutors about how to use expert witnesses, because if somebody's going to use an expert witness, I want them to know how to do it before I get there, because I don't want to be used in a way that that puts me on the spot, or I mean, the seat's hot enough. I don't want to turn up the heat anymore. So I want them to be really versed in how to what the best practices in using expert witnesses, and that's one of the documents that I sent. So yeah, there's a whole host of documents there that you can see, my CV, my resume, just to see how I put that together, a short little brief piece about what I'll testify to, a piece about how to prepare as an expert witness. So yeah, just hopefully a whole bunch of resources for you that you can draw from. Yeah. So anything that we need to clean up from our last conversation that we had with Muriel before we move on?
Just to add to it, I would like you to talk with everybody a little bit about the fees that are involved, the amount of time that it takes, kind of prep work. You know, if you've never been in court, you don't know that a 30-minute trial can take all day because you're waiting and then you're waiting. I'm just things like that, just to give people a peek around the corner.
Sure. Okay. So prep. Typically, as Muriel said, I don't know any facts of the case. So my prep with a prosecutor is basically, what are the questions you're going to ask me on the stand? First, how are you going to lay foundation that I'm an expert, right? So those are the questions I'm going to ask. What's your name? Who do you work for? approximately how many victims have you worked with, approximately how many offenders have you worked with, have you done trainings in this field? One of the things, so my my degree's in philosophy, right? So the defense attorney is going to jump all over that and say that I'm not educationally qualified to be an expert in this case. Well, they know that the statute doesn't require that, but they're going to do it anyway in front of the jury. So one of the things that I've learned over the years is how to take away what the defense can do with my resume. So in preparation with the prosecutor, I'm going to say, when you get to the point where we've gone through some of the trainings that I've done, then ask me, when you're training in CCR, or coordinated community response training, who are you training? I'm training judges, I'm training law enforcement, training probation agents, training community advocates. I'm training anybody who works in a government system, basically, about how to coordinate responses around this complex problem in a community. When you're doing a training on how to work with men who batter in a rehabilitation program, who are you training? Typically counselors, therapists, psychologists, clinical social workers, some advocates, some probation agents. So why would a therapist come to you for training? Well, this isn't a mental health issue. It's really a socially constructed one. And so these folks have training in how to work with in groups and one-on-one, but they really don't have their head around the problem or the best way to intervene in it. So that's what they come to us for training. Well, okay, so now what I've just done, I've taken that off the table, that they're going to say, Mr. Miller, are you a therapist? I'm not. Are you a psychologist? I'm not. Are you a police officer? I'm not. Are you a social worker? I'm not. Like, they're going to go through that whole litany, right? Well, I've just taken all that away by to say they come to me for training, and this is who my audience is. So that it's a way to deal with some of the objections that will come to you. So anyway, that's preparation. Typically, it's an hour, maybe tops an hour and a half in a criminal case. I charge $90 an hour, $45 an hour for drive time or travel time, and then mileage. So the reason I parse that out and don't just charge one big fee is basically tax reasons. I can't be taxed on expenses. I can be taxed on salary. So if I charge everything as one big fee, then I get charged all of it as taxable income, including mileage. So if I break out mileage, I can't be taxed on that. So that's why I break that out. A lot of experts just charge one huge fee. I'm not expensive, right? A lot of experts charge thousands of dollars to be present. It's not why I do the work. If I'm taking vacation time from my job, I want to be compensated for the time that I'm taking. Every year, I do a couple of these for free for women who are representing themselves and they have no money to pay. So yeah, it's part of what I'm trying to. It's just my personality, right? This isn't a big money making thing. So testifying for Muriel, her office is about 2.5 hours from Duluth. So that trip back and forth and the typical testimony time, which is about an hour to 2 hours that I'll be at the courthouse, I start charging $90 an hour the minute I walk in the courthouse. To David's point, if they end up making me sit all day long in the courthouse waiting to testify, I'm getting $90 an hour, whether I'm in the courtroom, as long as I'm in the courthouse and you wanted me there at 1 p.m., but I don't testify till 4, that's $90 an hour for every one of those hours that I'm waiting, okay? Now, interestingly, when I testified in a military court-martial, they asked me how much I charged. I said I charged what I just told you. And there was this long, quiet pause on the phone. And they said, could you charge more? I said, why do you want me to charge more? And they said, because our experts in federal court charge thousands of dollars. And we're afraid you won't look credible if you don't charge as much as they do. So they paid me $1,000 a day for 5 days. And I worked for probably one just to have me available, right? So that was a fascinating experience. And from so many different angles. But yeah, so the courtroom piece, I would really advise that go sit in a trial. Watch what people do. Watch what the defense does. Watch what the prosecutors do. Just watch how trials happen. Every time I go, the first time I was asked to testify in a family court hearing, what did? I watched 5 family court hearings, right? I want to know what everybody's doing. I want to know the rules. I want to know the pitfalls. I want to know the mistakes people get made. They get reprimanded by the judges. I want to know all that stuff before I go in. I want to educate myself. And before I testified the first time ever, I sat down with one of the best prosecutors I knew and one of the best defense attorneys I knew. And I said, I want you to grill me. I want you to just make it as bad as it can possibly be for me on the stand. And they did. And I learned a ton in that session with them, right? So spend some time trying to understand the space you're going into. Yeah, and just really educate yourself. It reduces the anxiety if you know what you're walking into, right? Did I answer all your questions, David? Yeah, okay. You get to charge whatever you want, really. I wanted to do the work. It's interesting work to me. So the more I charge, the less I'm going to get used. So I charge less than any other expert that I know, but I get to do it. And I like doing it. So, because it's interesting work to me. Yeah. Other questions? Okay. All right. We will continue. Jeff, do you want to bring up the next slide for me, please? Oh, no, here, sorry. Jeff said, I don't know where we are because I just like to go all over the place. Actually, we're not going to the next slide. We're going to the next exercise. So yesterday we finished on the 8 methods. And so from now, a big chunk of, before we get to the lunch break, we're going to work on this exercise. In your handouts, you have a handout that has 3 green bubbles across the top of it. If you could pull that out, please. And did I don't know if I have that. Jeff, do you want to put it in the chat just to make sure? Okay, so what this is going to do is going to walk you through an actual problem that we ended up solving in Duluth. And it's going to give you what our solutions are towards the end of it. So you'll have to read the problem. I gave you a brief synopsis of what we learned when we did the case review. I did give you a brief synopsis of what we learned from the focus groups, what the actual problem was, and then how we ended up solving it. So you don't have to solve the problem. What you're going to do is you're going to take the solutions that we came up with, and you're going to, in your small group, run them through the 8 method worksheet. Thank you, Jeff. You want to just pull that up? Can you? Are you sharing the screen? Okay. Okay. Yeah, why don't you do that? Jeff's going to share the screen here just so I can kind of walk you through. Okay, so this is where we are in that bubble map that I gave you, right? Identify and document the problem, expand understanding, identify sources of the problem. So the narrative underneath this is what goes to those 3 bubbles. Jeff, if you could scroll down just a bit. Okay, so then you get our work group findings, you get our focus group findings. The actual problem is eventually identified, and there's multiple sources to this problem of the city attorney's office dismissing domestic violence cases. Okay, scroll down a little bit more, Jeff. All right, so now we get to the bubbles: approach and involve decision makers with a proposal for change. Work group meetings, develop solutions. Now, if you scroll down a little bit more, so we know that these 2 agencies, the law enforcement and city attorney's office, are contributing to the problem of dismissed cases. And
Scott,
so,
we're not seeing what Jeff is scrolling to. It's just showing the bubbles still.
oh, huh, that's curious.
There we go. There we go.
Now I can't see it. But I should know it because I wrote it, right? Okay, so Jeff's gonna put it on a different screen for me. Yeah, I can see it. Can you see it now? Okay, good. All right, we just did something different. Okay, so if you scroll down a little further, Jeff. Okay, keep going, keep going. All right, stop. All right, so now we're at the bubble where, if you could go back up just a tad. Draft initial proposal for change, check with experts. You're gonna see 4 different solutions, again, an abbreviated version of them, listed there. The number 2 is turnout training and policy regarding interviewing witnesses. Now, that particular one, the police department had a policy that required all officers to interview all witnesses and document their contact information. That wasn't happening on the street. So one of the solutions was you already have a policy for it, but you're going to have to do a turnout training to make sure and reiterate it from command that you need to be doing this. Second thing is there's a supervision issue, because if that many officers aren't doing it and it's getting through the approval process, then the supervisor or the sergeant is approving reports that they shouldn't be, right? So what really needs to happen is a reemphasis on the policy and a reemphasis on supervision of execution of the policy to make sure that officers are doing what they're supposed to do, right? And then 1, 3, and 4 are new structural or policy changes that were put in place to deal with this problem. So Jeff's going to put you all into 4 groups. So you have a bigger meeting, right? That you're going to have than typical. And group 1 will take change number 1. Group 2 will take number 2, 3, and 4, right? So whatever number group you're in, you're going to take the solution number to run through the 8 methods. Now, Jeff, could you pull up and share the 8 methods worksheet? Okay. I'm asking Jeff to do things that he wasn't prepared to do, but this is what's working with me is like, it's not on my screen, this screen, no. It's on this one, yeah. Okay, thumbs up, you can see it? Okay, all right. So this is the 8 methods worksheet. These are the 8 methods we covered yesterday at the end of the day. What I want you to do is take that solution and run it through these 8 methods, meaning that if you're taking, for example, the turnout training, number 2, the one that I use as an example, what's the mission, purpose, and function of that solution? The function of it is to reiterate existing policy and to reiterate the way in which that policy will be supervised. The next one, rules and regulations, already existing policy, unchanged, right? I don't want to go through the whole thing because I'm going to basically take group 2's, kind of fire away from them, but that's what you're doing. It's really to help you begin to have a lens for thinking through how to solve a problem within a large agency, and to think of all the different ways in which that policy or that solution needs to be filtered through these different categories, okay? Think about accountability, how would you train on it, right? All of that stuff. And you don't have to come up with the exact right answer. There is no exact right answer. There's just really the exercise is about giving you a different lens for thinking about system change than just, hey, we need a new policy. Well, we need a new policy, but we need to link it to other agencies. How are we going to do that? We need accountability. We need supervision of it. Is it accountable to the victim? Is it accountable to the offender? The due process. the workers, the individual practitioner who's going to execute it, how are they going to be held accountable to that? Are they accountable to another agency, right? You're thinking through all those different levels of accountability. What kind of concepts or theories are behind that behavior, that action, that policy, that structural change, right? And what resources do you need to actually pull that off, right? So a lot of what you're going to do in this exercise is speculative, because you're just going to be kind of guessing as to what those things might be, because it's not actually happening in your community. But again, the exercise is more to help you think through this lens than to actually try and solve the problem. The problem has been solved. You're just running it through these 8 different categories. So any questions? Jeff, could you give me the whole group back again so I can see the room? Thank you. So any questions that you have on what we're going to ask you to do? Does it make sense what I'm asking, or am I being clear? This is a newer exercise. David, your eyes are looking up. Does that mean I'm not being clear, or that you're muted, David?
I have my own document that you have up, so I'm looking at all my screens with your documents.
Oh, okay, got it. Okay. All right. So any questions about what you're going to do in your small group? Again, I will jump in and just see where your conversation is and answer any questions, because you'll have some. And I'll make myself available to all of you once you get going. Okay? All right. So Jeff will send you the invitation. Again, there'll be 4 groups this time. And remember, when you accept the invitation, it will tell you what number you're in. And then that's the solution that you're going to run through the 8 methods worksheet. All right.
Beam us up, Scotty.
Beam us up, Scotty. It's good to have another Trekkie on board. All right, so you're back. Now, I went through all 4 groups, and there's a continuum of success here. Mixed results, I think, would be the best way to grade myself on this one. So one of the things that was interesting to me is that this is a really hard exercise if you don't know how criminal justice agencies are structured, what their hierarchies are. So if you don't know how to embed something like a new position within a department, that can create a whole bunch of confusion. So so that was interesting to me. I've used a version of this before. This is you know, a different way of I'm doing this exercise, but I've done it with teams where they've had all these players in the group. So there was always a resource to say, this is how it would play out. We didn't have that here, so that made a difference. So group 3, you guys knocked it out of the park. You got it. That's great. Group 4 did a great job. Group 3, once you kind of got that conversation about what the infrastructure is, or group 1, then you're on your way. So give me feedback. Now it's time for me to listen rather than lecture about what was helpful about this and what was not so helpful about this particular exercise for you. And let's talk through that. What was helpful? Carla, I can see your face. It's telling me something.
Yeah, sorry, I'm kind of doing 2 things at once and I was very confused. But no, what was helpful, especially with taking kind of a break between, learning about the 8 methods yesterday and then doing the work today. At first, the break was confusing because we had to kind of relearn the information, but I also think was in a sense helpful versus just kind of learning the information, putting it away for the evening and never kind of having to retouch on that.
Okay.
So I think I am a person who learns really well when I have kind of these scenarios that I can utilize what I've learned into kind of like a real life scenario. So in that aspect, it was very helpful that way.
Okay, all right. And so what was not so helpful? How would you improve this?
I don't know if I have an answer for that.
Okay, right. All right. Who else? Q, how about you?
Yeah, I think what was helpful was, I think even just the opportunity to problem solve something that we were all a little confused on, but with different people in the group, because everybody had a different perspective about how they'd approach it based on where they were from. So I think that was really useful because we all had different ideas about that. I think what would have been helpful, I think our group talked about, was having some sort of examples, maybe like an example case before doing one like independently as a group, just so that we had like a clearer idea of, oh, this would go here, or this would, I think that's where we were like getting a little lost and kind of going all over.
Sure. Yeah, that's great. That was great feedback. Yep. Good. Lauren, how about you? You're on mute, Lauren.
The hands. I have to agree that I think looking at that, I'm the type of person that would like to look at an example, make a real life scenario, and then, be able to plug it in. My problem today is it was hard for me to plug in, the information that I didn't know. Like you had mentioned, the protocol for police, or, who would be above the city attorney to make sure they're following suit and have supervision. So that was a little awkward, but we made it through, and we came up with a great plan. So
yeah, you did. So in fact, you actually came up with something that actually ended up happening that you weren't even told about. So that was great. So, all right. So this just really speaks to how important. So when people call me up and they'll say, all right, we got awarded a grant to encourage arrest from OVW to do some system change work in our community. And we're going to hire somebody to coordinate the work, and we want to get them on the ground running. What should they start with? The first thing I say is do not have them start addressing the goals and objectives of the grant, because your team is likely not ready for that. Give this person time to make connections in police, make connections because grants to encourage arrest are for criminal justice change. Police, prosecution, probation, the bench, court administration. Give them 6 months to observe all of these systems and structures and learn them. Because this exercise, when you don't know what that structure is, how would you ever go in and suggest a solution when you don't even know how they're structured, right? So one thing this exercise did expose is how important that piece is, right? Because you can't go in and say, well, why don't we add a divert investigator and not even know what that means, right? Lauren, it looks like you're saying something, but
just agreeing.
Oh, okay. All right. So, yeah, I mean, you've got 3 years on a grant. I think they're still 3 years long. Spend the first 6 months just doing ride-alongs, doing sit-alongs. And what I mean by that is calling up a prosecutor and saying, we've got this grant and it involves all these different agencies, but before I really even get going, I think I need to spend some time learning about everybody's role. And so would it be possible for me, when you go to pretrials next week, for me to just sit behind you and watch what you do? And if you could just explain to me what you're doing and why you're doing what you're doing, that would be really helpful to me. I have never had a criminal justice practitioner say no to that. In fact, what I hear from them is that, well, this is amazing, because everybody wants to tell me I'm either doing a bad job or I'm doing the wrong job. And nobody has ever asked if they could just learn what I actually do, right? And I don't care if it's a judge, a police investigator, doesn't matter who it is. This is new to them, that somebody actually wants to understand the role that they play, the job that they execute, right? And once you go through that, you're going to learn all of the stuff that you need to know to then start partnering with them on solutions within their agency, right? But you can't do it until you understand how it's organized, what the culture is, right? Yeah, good. Other thoughts? David, what do you, I mean, this isn't the first time you've done domestic violence training, so what are your thoughts? I'm curious.
I liked the 8 methods worksheet. And I think that gives us a structure to think about. It's the solution is, and mapping out the solution, I'll put it that way. The document that we were working off of, I think was probably 10 pages too short.
Yeah.
To really meet what it is for all 4 areas to understand it. And a lot of our time was focused on, okay, what's Scott asking us to do? And you came and helped us, but I don't know that it was clearer, but it wasn't crystal clear still.
Sure.
Yep. But the plotting out of a structural solution and thinking beyond, we'll just do it kind of thing I think is very useful.
Yeah. So I think for me, one of the lessons learned here is that is really the conversation about how important it is to understand the agency or the agencies that are involved in any solution before you ever get to an 8 methods conversation. You like David said, you need 10 pages more information about the structure, what it means to put it in there. What I've done in the past is I've given people this exercise and they've come up with a solution within their own community. And so that kind of took away some of that because they knew their own community, but then they struggled with how to solve it because they didn't have the piece about what it would mean to, for example, change the structure of an agency. Because they, again, hadn't been in that agency or done the work to really understand how it was organized. So yeah, I think the exercise needs work, but there were some learning pieces I think that did come out. The lens of really thinking through all the different ways we need to put our suggestions or solutions through if we want them to be sustainable, and the importance of understanding the structures and the organizations and the cultures in which we're going to be walking into. And like I said on day one, when I'm walking in the police department, it's a whole different personality than I'm walking in 911, then I'm walking in to a bench meeting, right? Because everybody's got their own culture, everybody's got their own language web, everybody has a different way of thinking about the work, and I need to know all of those things to navigate them, right? Yeah, good. Good. All right. So any other thoughts, comments, or questions that you have before we move to the next thing on the 8 methods, basically? All right, we will then move. All right.
I couldn't find the button, but I just want to say, the 8 methods worksheet, I think, works beyond systems change. It could just be something that you use internally in your organization to think about strategizing a solution. It doesn't have to be macro, it can be pretty micro.
Right, and it applies to any, I mean, how do we standardize workers' actions? Doesn't matter what the agency is, right? This is how we do it. So yeah, you're right. It could apply to your own agency. Aaron, you get your hand up.
Yes, I'm sure like many, as everyone else here, we've all been doing a lot of strategic planning. And that's like kind of when I saw this, I was like, oh, here we go. I'm another strategic planning and just how that goes. But I think for me, it's just like this worked a lot better. It was easier, it kind of flew better, and just trying to, really be objective is what you're doing. So I actually can see how this could even just translate to doing, other improvements, professionally in other areas. So would prefer this way over like a standard strategic planning method. So.
Yeah, you know, to your point, Aaron, like when you're strategic planning, there's an abstractness to it, right? And this is pretty concrete. What do we, these 8 steps are asking me specific questions about what needs to change, given whatever kind of a thing we're imagining, right? And so, yeah, I'd not thought about that way, but that's accurate. There's a concreteness to it that is quite helpful. So, yeah, good. Okay, what we're going to do now is start shifting towards how do you evaluate? So if you've done all of that work and you've put something in place, right, and you hope that it has the intended consequences, then how do you then track and monitor that piece? So Jeff, do you want to pull up the next slide? So that would be this last bubble on that change map that we've been referring back to time and again here. How does evaluation play a role in what is we do? And evaluation, and that can mean a lot of things. I mean, you can pay $50,000 to have a researcher and they'll eat up, 25% or 30% or 40% of your grant, coming up with some research answer to your question. You really just want to know if it worked. If you want to prove something to the world, then maybe you want to hire a researcher. If you want to know as a community, do we have some evidence that what we've done is having the desired impact? You don't need a researcher to do that. There's ways that you can build in to your processes to evaluate that. So we're going to talk about that going forward here. So next slide, Jeff. So this is how we distinguish here the difference between tracking and monitoring. Just because there's 2 different activities and we need a word for them. Tracking is used to determine if a problem or trend exists. Does a downward plea impact recidivism, right? We don't know the answer to that. So this came to us from our city attorney's office again, and they said, we're getting a lot of criticism for dropping misdemeanor charges down to disorderly conducts. And we want to know if the recidivism rate for men convicted of misdemeanors, which is a higher charge, is less or greater than men that we drop their cases down to a disorderly conduct as the conviction. So now they're not convicted of a domestic assault, they've got a disorderly conduct. All right, so we go back to our data and we design a way to track that. So we've got all this data that we've collected on different cases in our database at DEIP. Now we figure out a way to track it, right? To see what is the answer. I don't know, right? Monitoring is used to establish if policies or procedure are improving over time, right? So after we've implemented a policy, like the one here where we added a divert investigator, are less cases getting dismissed, right? That's what we want to know. We're monitoring an existing policy that we put into place to see if it had the desired impact, right? So tracking is about trying to follow something to see what the answer is, and we don't know, right? Monitoring, we have something we've done, we've implemented it, and now we're trying to see if it actually works, right? So that's how we distinguish those 2 things going in our evaluation, under our evaluation umbrella, right? The data is always designed and used to improve the community's response to domestic assault. The reason that's there is because if you collect data and you have data at your fingertips, you have a lot of information, right? That can out somebody's poor performance. So there is a tremendous amount of care that we take with the data that we are given by the system. So the amount of data that we have, we could tell you who the police officers were. In fact, Jeff, how many different data points on a police report do we collect? We collect 300 different data points on every police report in Duluth. That just gives you some idea just on police reports, how much information that we hold, right? So if I go to Jeff and I ask him for some information, Jeff's going to ask me, what are we going to do with it? and how do I need to frame it, right? Because we don't want to frame it in a way that makes somebody look bad, because that's not the point. The point is to improve the response, not out anybody for not doing the job that we think that they should do. There are things that I will get requests from command. I had a lead prosecutor call me and say, can you give me the dismissal rates for all of my prosecutors, right? Because I can't look that up, and the way that we've got our system designed, I could do it, but it's really laborious. But I know you've got it. Can you get me that? I can. So the request came to me. I go to Jeff. I ask him for that information. I give it to that prosecutor. And the only two people in this agency that know what that looked like was Jeff and myself, right? We didn't share that with anybody else in the agency because it's not our information at that point. It's theirs to use for supervision, right? So that's how we can be a partner. But I just want to really reiterate that if you've been given the privilege to access information from the system about practice, that there needs to be a lot of care taken about how you use that information, where it gets presented, how it gets presented, when you're talking to somebody more than just the agency that involves that information. Does that make sense? Right? Okay. Next slide, Jeff. These are the methods of tracking and monitoring that we utilize here. Focus groups. Implement the policy, wait 6 months till we've got some cases that come through that intersected with that policy, and then we go back and we see if there are women, typically, who are victims who are willing to talk to us about what it was like to go through that experience. And I gave you the experience on day one where the prosecutors wanted officers to be asking about whether the victim had used any alcohol or drugs or medication prior to their statement to police. And that landed very differently with white women versus indigenous women when a white cop was asking. So we had to redesign the way that was delivered, given the different way it was landing in different communities within Duluth. Reading reports and case files. This is a big one. In this particular example that I gave you, this is how we figured out what one of the problems were, is that we sat down and read 50 reports and we have no idea what we're going to find. Sometimes we don't find anything because that's not where the problem is. But this time we sat down, Ellen, Mary, myself, we read 50 of these reports, and virtually all of them had multiple witnesses that were not interviewed. And so when we ask frontline prosecutors, what happens when you get a report that has all these witnesses that weren't interviewed, they say, you know what, it's not a strong case to start with. It just got a whole lot weaker. We just dismiss it because we have nobody to send it to for follow-up investigation. We don't have time, right? So that was the problem. And we found that by reading one report after another. It's amazing what you find doing case review, right? But in case review, you're always doing it in partnership with the agency that holds the case. I mean, I'm not going to pick up 50 prosecution files and bring them to our office, right? I'm sitting down with a prosecutor who's donating the time to look through to see if we can find any trends or issues when we look through all of those cases. And I got different questions than they do. They have different questions than I do. And we come together. When we had juveniles being arrested in Duluth or in St. Louis County, we took all 22 arrests of juveniles who fought back against a caregiver and were arrested for domestic assault. And we read those as a CCR team. We had law enforcement, we had juvenile detention, we had advocates, we had a prosecutor in the room, we had a social worker in the room. And we all read those 22 police reports and we all saw the same trend. These kids are acting in self-defense, but nobody's assessing for it. Not that they weren't all acting in self-defense, but many of them were. An example would be Guy gets up Saturday afternoon and he comes back home with a bunch of beer, puts it in the fridge, grabs a beer, starts drinking it. The kid, the 16-year-old, goes in the fridge and grabs the beer, goes out to the porch and throws it at his dad and says, "Why don't you just get effing drunk?" And his dad gets up and says, "You don't talk to me that way." The kid retreats. He retreats off the porch. He retreats into the kitchen. He retreats out the back door. He retreats through the backyard. And now his back is up against the garage and his dad's in his face and he knows what's coming. So he hauls off and hits his dad before his dad pounds him like he usually does. And the kid gets arrested, right? That is a clear act of self-defense because he knows what the man is capable of doing because he's done it before. He's attempted to retreat. It did not work. And he was about to be assaulted and he had good reason to believe so, right? But he's the one who actually ended up incarcerated, right? That's the kind of thing you see when you start reading these reports. So then the question comes, well, why wouldn't the officer know that? And what did command say? I know the position the officer's in. And under Minnesota statute, there's no provision for a juvenile to use violence against a caregiver. But it is allowable that a caregiver can use violence against a child, right? There's an allowance for that. So if a child used violence in return, they committed a crime. Doesn't matter what I think, right? Well, okay, let's give them a tool to think through that in a different way. So the self-defense predominant aggressor tool that we gave them for women who fight back now applies to juvenile arrests. And they have to call a sergeant before they actually make the arrest of the juvenile, so that it's a collaborative decision between command and patrol to take a juvenile into custody. That's an example of where we tracked the problem. Then what we did is we implemented the policy and then we monitored what happened afterwards. And it reduced the arrest of juveniles, right? Which was the goal, right? Okay. Reviewing criminal justice databases. Again, these are becoming harder and harder sources of good information because the trend seems to be in many criminal justice databases that you can look up all kinds of stuff on an incident, but you can't query across data, across different incidences. And it becomes harder and harder to do that. And I think it's because of data privacy kinds of legislation that's been going through our legislatures. So when we get information from the system, we put it into a database that we've designed that allows us to quite easily pull all this data together and look for trends, because that's what you're looking for. You're not looking for an incident problem, you're looking for a trend problem within the system, right? Observation. Again, when I told you about how we pulled all those people together for 911 and dispatch, and we listened to those 20 911 calls as a team. Okay, 2 years later, after all the work and redoing all of our policies and protocols for domestic assault, we took that same team, we went back and pulled 20 random 911 calls, and we reviewed those the same way we did the first time. And it was like a complete difference in what we heard call takers. Not only were they staying on the call the way that they were supposed to, which was a problem in the first one, but they were also much more engaging with victims, right? And the other thing they were doing that we heard from the focus groups was that the whole point of me calling 911 is to get them to send somebody. But they don't tell me that they send somebody. So I'm going to sit there and I'm going to continue to argue with 911 to get them to send somebody. But when we looked at the dispatch sheets, virtually all these calls that they were having this argument about, are you going to send somebody? And the 911 person not saying anything about that, there was a squad being dispatched within 30 seconds of the call, but they never told the victim, right? So now we heard that happening. So all the things that we built into that policy, we're starting to see come to fruition. We achieved the goal. They're doing what we asked them to do, right? It's having the desired impact. Okay. And then our DANE database, the one that we use here that we designed, that's a specialized domestic violence database where we could track, like I said, 300 points on a police report, or every prosecution hearing and what happened, and who the prosecutor was. We can track all of that information. So it gives us just a great resource to be able to look for trend problems within our system, or track solutions if need be. All right, next slide, Jeff. What does tracking and monitoring do? Trends. It gives you trends, identifies system gaps, adherence to new policies and procedures, service to partners agencies, and improved advocacy for better women and their kids, right? Like this is the goal. This is what CCRs do, right? Look for the problem, solve the problem, see if the problem was solved, right? Essentially, that's the core work of a CCR. The database work that you do can really enhance your ability to do that. When I first started, Ellen gave me a box full of 400 order for protections and said, go through every one by hand and see how many men were ordered to men's group. Now I say, Jeff, how many men were ordered to men's group in 2010 through 2019? And he can just, in a few minutes, pull a number and there it is. So yeah, databases really, really speed up the work of a CCR. So a question that I have for you at this point is, does anybody use any kind of specialized database in their community to track domestic violence cases? Or is this new? Is this a new idea? Johnny, I see that you're, yeah?
Yes, we use a database to track.
Is it community-based one, like in a community agency?
It is somewhat. It's something that we've created through Excel, which I'm a big Excel person, and Excel is a database. So we all share the input of the information, and then we were fortunate enough to get a grant through Microsoft for OneDrive, and we are able to not only protect but disseminate that information as need be.
Okay, so how did you decide what information to collect? What was the process for that?
Well, we had a list that was public about how many arrests were made. So there's a list that comes out daily of who got arrested for domestic violence. And from that, we would get a list from NM courts as to who was actually had charges filed on. So there was quickly a discrepancy by the number of arrests we identified and the number of actual cases that were filed. So that was information that was, the DA really said, well, why aren't we following through with filing these cases? Why isn't it in my office? So that was one example of some of the data that was being gathered. The other one, like you said, the number of convictions, we wanted to make sure and track, because in New Mexico, it's kind of funny. You are ordered to a BIP group if you're convicted of 2 of the 4 batteries or assault on a peace officer. If it's the simpler ones, it's not in order. So a lot of times the case is pled down, and you were wondering, why aren't we getting this ordered? Well, because the plea was to a lesser crime. So we showed that there was a discrepancy there, and then we went to make sure that maybe a condition, the prosecutor would say, I'm going to go ahead and plead it to where it's not mandatory by statute that you go to a BIP, but we're going to include it as part of your plea agreement that you do complete the 52 weeks. So things like that we were bringing out.
Okay, so that's a really good example. And it's something simple, from the number of arrests to the number of charges, and what came out of that conversation. Now, again, in your communities, you're kind of coming to an agreement about, okay, am I going to get the data, right? And if I get the data, what am I going to do with it? How am I going to protect it, right? And how long am I going to hang on to it, right? So our agreement with the Duluth Police Department is that we'll keep hard paper copies of police reports for 5 years. After that, we shred them. All the data points that we pull out of it, though, we have in perpetuity inside of our database. But the hard copy, we don't keep past that. It's always kept in a room that has a locked capacity. So there's a lot of different things that we've agreed to that we don't have to actually do by statute, but this is a partnership. This is a CCR, right? The statute in Minnesota that allows us to get these does not say what we have to do with them or what we can't do with them. But we don't give them out to victims who request them. We help them get them directly from the police department so that they can track who all has a copy of this report, right? That's what we've agreed to do through our MOU with the police department around police reports. So yeah, it's always a conversation about, if you give us the data, then what do we agree to as far as how we're going to hold it, use it, and share it, right? Regardless of what your statute says. Yeah. Judith, you jumped in for a second. Are you still there, Judith?
That may have been unintentional.
Okay, she's a police officer, so I just thought that that she might have had some question around what I was saying around police reports. So, all right. Anybody else use a database for their work? Any other CCR team or judicial counsel use databases or information you get from databases? Okay. Well, again, that says something, right? I mean, that is a crucial tool in being able to determine trends in a CCR. Otherwise, the only thing you have is anecdotes, right? And so if Johnny's the police chief, right, and I knock on his door and I say, "Hey, chief, I got a story I got to tell you about something that one of your officers did." Johnny's like, "Okay, I got 200 officers, man. I don't want to hear a story about what one of my officers did." But if I go to the chief and I say, we've been looking at the last 2 years, and 20% of your officers are not asking victims the risk questions. And it's kind of a core group of officers. There's about 8 of them that are doing this about 20% of the time. So I'm wondering if we could have a conversation. Now I've got his ears, right? Because that's something that he can wrap his head around, right? That's something that can be solved. But if I've got a thing I want to talk about what one officer did, he's got a lot bigger fish to fry than that. So trend data is very motivational for the system to be open to change. Just like focus group information is motivational, trend data is very motivational. Yeah. All right, we are at our lunch break, and I don't want to invade that any further than it is. So we will take our 1 hour. We'll put up a timer, and we will see you back in an hour to finish up the day.
Well, everyone, I'm still looking for Scott's call. I just want to say how glad I am that everyone is able to see this DAIP model is so much more than what the world thinks it is. The world thinks, at the very least, oh, that's the power and control wheel place, right? Or that's the men's curriculum model. But again, it probably makes more sense when it probably makes more sense when I'm saying it on day 3 of this than on day 1, that the Duluth model is what we're talking about today, and the add-on is is what we've thought about it before in terms of, you know, the power and control wheel over the men's program. Scott, you're on your phone, is it? And,
All right,
and
yes.
now you have clever things to say.
Now it's really got to all be about substance. There's no more flash.
Okay, so tell me what slide you want to be on.
It would be slide number 88. So David, you already laid out the problem for everybody so they know what's going on?
Yes.
All right. I apologize. This is the first time this has happened, but we knew it probably would at some point, so. So we'll just continue our conversation where we were and finish up this conversation about monitoring and tracking. So remember when I talked about how one of the things you need to do is really spend that time on the front end of a project, getting to know people, knowing how their agencies work, what the culture is, what structures they have in place, all of that, how they process cases. In the process of doing all of that, you're building trust. You're building a relationship with people that they can trust your intent, your motives for coming into their space, right? That's that kind of trust that you're building is really what is crucial to getting access to data, because I mean, fundamentally, we're not going to share data because we don't trust what you're going to do with it. So there has to be a really kind of clear conversation, if not a formal MOU, saying, if you're willing to share this data, and this is why we need it, right? You got to know why you need it before you ask for it. And it can't be just because it would be helpful. It has to be helpful how, right? And what exactly are you going to do with it? Who's exactly going to see it? Where's it going to go, right? The biggest fear that a lot of agencies have is that their information that is sensitive is going to end up in the press. Is going to end up in a wider kind of audience. And so you really want to make sure that the trust is there, but then you have a formal way of talking about how this information is going to be used going forward. So access, understand what you need before you ask for it, right? Understand what partner agencies need, because that's going to be part of why you need it. If you're the CCR coordinator or that agency that's housing the CCR coordinator, who are your allies that can help you craft the argument to command, whoever that is, that access to this information is going to be important, right? There may be some legislative limitations to what you can get. For example, if I'm in Duluth, I'm not going to go knocking on the door of court administration because they can't even share the fact that they exist, much less the data that they hold. So that's just going to be a way for me to lose credibility if I don't already know that. So I know I can go to the police department and get some things. That's where I'm going to start my conversation. Integrity, responsibility, and honesty. Misuse that information once, and it could be the end of your access. And I can't tell you how many times over the years, somebody from a community-based agency that knows we collect all this information calls me up and says, hey, I met this guy, and could you run him through your database? Okay, no, we can't vet your dates through our data. It's not an appropriate use of the information. We had an employee who was filling in for Pat when she was out ill for a while. And what happened was she used Pat's password to get into a police database instead of the one she was assigned. That is a huge no-no within that space. Everybody who goes in and gets confidential information has to be identified. And she was using somebody else's identification to do that because hers wasn't working. But instead of getting up and going to IT and saying, hey, my access isn't working, she just shortcutted it and used somebody else's password, and she wasn't allowed back in the building. That was done. So there's not a lot of room for mistakes when it comes to this because of what each of those agencies are held to as far as liability for the information that they hold. So this is serious stuff. And access to it can greatly enhance your response, but the seriousness in which you hold that information is quite important. So, all right. Next slide, David. What's that? It's a habit, isn't it? Yeah, it is. It's really just and I'm running a whole different show here. So, all right. So access agreements and data, draft memorandums. Jeff, would you put down just to jot a note? I will give you a memorandum that we currently have with law enforcement about getting reports, so that you can just see. And these are all basically Word documents. So if you want to build something off of something that I send you, it's easier to do rather than retyping a whole PDF. I'll give you the Word document, and then if you want to edit it to something that fits your circumstances, you can do that. Basically, we've talked a lot about this. How will data be used? How will it be accessed? I mean, in other words, when you get you can have the information, but now how are you going to get it, right? What's going to be the means? And that's a resource conversation. Are you asking them to produce it for you? Or are you going to be allowed to go in and get it? I'm
on my way.
Oh, there you are.
Okay. Okay, so we are now running off an emergency backup hotspot that we bought for instances like this, but have never used. So it's working. I'm going to be happy with that and not question it. So, all right, we are back. I feel comfortable again. How will data be accessed? How will you make the data available, right? Anytime we do, like, for example, if we're going to go to a police command meeting and we've got information tracking individual officer performance, we're always going to bring that to the chief or the deputy chief prior to bringing it to a command meeting, right? Somebody's going to vet this. I'm not going to go to a meeting with an internal agency's information without clearing it with command first, right? Even if they've requested it, even if they know I'm bringing it, I'm still going to show them what it is, right? In case they've got any way of thinking about how it gets delivered, if it should get delivered, what should not be delivered, what should not be, all of that stuff, right? It's their agency, it's their information. I'm just the bridge to it. And I want to, there's things to talk about, but they have a hand in, a partnership in talking about how that gets delivered. Okay, next slide, Jeff. All right, internal. I would strongly suggest that your agencies have a policy about how you're going to use data internally and externally, so that there's no questions about how information gets used, shared, exposed. If you go back to the slide, Jeff. All reports are internal. Create new process for all reports that will be external. So everything is internal until you decide to expose it, and then there's got to be a filter about how that information is going to be put together and exposed to whoever it's going to go to. External meetings are multidisciplinary, single agency, are used as a supervisory tool. This is why we typically, or the format that we typically end up using data in. It's not too often that it's a supervisory tool. It's more to say, we are either complying with the policy, we've achieved our goal, this is the data that backs it up, or this is how far we've come. We were here, now we're here, and we'd like to be there, right? And the data backs it up. Now, the data isn't going to do anything other than say where we are. The conversation, then, it's going to be a conversation starter to say, how do we need to continue to either improve accountability in the police department? I keep using that example, for compliance to the policy, or do we need a new strategy in place because we seem to hit a ceiling as far as compliance? However, that conversation, but the data really ends up being the conversation starter, saying this is where we're at. Everybody can agree on the numbers, and then we talk about strategy from there. All right, next slide, Jeff. Next slide, Jeff. Okay, defining a success in a CCR. Again, think about your own judicial counsels, and you know what you are accomplishing. I mean, I don't, but this is our list. I want you to be reflecting on yours. And is there anything that matches up? What is organized has an impact on victims and those who batter, right? So are you organizing things that you can say have an impact on victims? One of the things that I look for when I go to a conference is if somebody stands up and says, we got this great new thing that we're doing, and I think everybody should do it, and they never talk about its impact on survivors, I kind of like flatline a little bit, right? Because that means I'm going to have to take this idea, bring it back, and figure out how it's going to intersect with survivors, because it wasn't developed with them in mind. They weren't a filter to this process. And that really is, I think, fundamental to any of the stuff that we end up organizing. Victim input and experience is reflected in the changes made. So you can say, if you talk to survivors in your community, and they said that this is something that really needs to happen, I need to know that 911 has dispatched a patrol car because I've called for help. There's a way to track that. There's a way to know that you're actually doing it, right? Criminal justice agencies experience and improved work experience and outcomes, right? Is their work actually better? Is it improving what they do? They'll tell you. Meetings are useful to everyone. Change is slow, but it's change. We talked about that. Tracking efforts show improved outcomes. Trust exists between community agencies and the criminal justice system, and community advocates are a resource to the process. They're not, you know, like a lot of communities I go to, I get this like thing where people start rubbing their head and they say, well, advocates are just always so upset, you know, and it's like, okay, maybe there's a reason that they're upset. So, Angela.
Maybe it's the red hair. I don't know, but I can't.
No, I don't think so. I'm feeling your advocacy. Right? They are looked at as a resource. Sometimes men's programs will say, you know, boy, it's a real struggle keeping a relationship with them because they don't trust what we do. That's okay, right? Because I can learn a lot if Angela doesn't trust what I do, right? And she questions whether the change work is actually going to have traction with the guys that are doing what they're doing to the women that she's working with. I can learn from that, right? Because that's not just made up, right? She's got examples, she's got stories, right? About what women are saying about the guys in the program. I can learn from that rather than judge it, learn from it, right? Tension can often be a very creative force within a CCR. We used to have a movie that we've lost track of. I just so desperately wish somebody would just stumble on it in some box somewhere. But it's a CCR meeting from the early 1990s that just blew up in Duluth. Like people just couldn't stand each other, right? And were pointing fingers, and it completely fell apart. But what came out of that eventually was the first prosecutorial direction on how to work with victim defendants, I believe in the United States. So that kind of tension can be quite creative. And I think anybody who's been in the work long enough knows that with the passion that we carry and how much we want to do good work, eventually we're going to disagree, right? We just can't be disagreeing in ways that are obviously going to ruin relationships, but it might take time to come back together. Next slide, Jeff. All right, so I know recidivism isn't the greatest tool to check for how well your system is doing, but here's how we use it. The criminal justice system, we have went to them and said, we want you fundamentally to spend more time in these cases. more time means better outcomes. If you're going to spend more time, is it having an effect, right? So we can go to them and say that, depending on which one of these you want to look at, 29%, 30%, nearly a third of the cases that are 2/3 of the cases that you end up dealing with in the criminal system won't be back in that system 8 years from the last time they have contact with it. So that helps them understand, okay, I can invest in this, right? We're not just having a revolving door where people get arrested, they get convicted, and then they're back again, right? Most of the people that we deal with come in and leave, and they're not back in that system. So it isn't so much a benchmark for this is how successful we are, as it is a benchmark for the system to know that they're having an impact that is reflected back on them in a positive way. Lower dockets, less going back to the same house time and again, that kind of thing. David.
Because you brought up the issue of recidivism data not being that great, would you mind sharing some of your thoughts about that for everybody?
Yeah, so if you're thinking about actual harm to the victim, there could be, the weakness of it is that victims aren't always calling. In our experience working with survivors, when the amount of abuse that they experience that they don't report is tremendous. The vast majority of it, they don't report. When they do report, it tends to be when their back is up against the wall, that they don't know where this is going to go. Something is different in his violence. Something's different in his persona that leads them to almost panic, grab the phone and call for help, right? Otherwise, they wouldn't be. So as a determinant about violence in your community, it's not one of the best ways to do that. Also, people move, right? We don't track the people that come and go. So we don't know how many people left. We don't know how many people stayed in the 8 years that we're tracking them. Yeah, so that's just off the top of my head. But David, do you have anything else? I know you've got things you can add to it. So
I could, but I think that we could probably do a whole nother at least 2 hours on that. So I don't want to take you off course.
Yeah. So really what I want to say is that this is an inexpensive way for us to track something and give the system back some data that says that the extra time and effort you're putting into this is having an effect, right? And it doesn't cost us anything to do it other than some of Jeff's time to put the query together and run the numbers. So again, it's not really a lens into how much violence is being experienced in Duluth. It's more about how much is the system having an impact on those who end up entering it, as far as coming back into that, either in the civil or in the criminal venues. And again, our benchmark for recidivism is really low. It's arrest. If they get arrested, it doesn't matter if they're convicted. If they get arrested, that's a new offense. If they get an order for protection granted against them, that's a point of recidivism. So we kept it quite conservative when we set up what the benchmarks are for recidivism, because that's what they have to deal with. If they're rearresting somebody, now they're back into that system. Doesn't matter if you can prove it, just means they're back in and somebody's got to deal with that and spend the time. So yeah, does that help at least kind of vet why and how we use recidivism in a CCR? Inexpensive, and it gives data back to the system to let them know that they're having an effect by doing something different than they were. Yeah. Okay. All right. Next slide, Jeff. All right. Next slide, Jeff. All right. So we're going to listen to Dr. Ed Gondolf and Ellen Pence talk about the connection between sanction and rehabilitation, because we're getting we've been going through that CCR system, and now we're towards the end of it, which is typically rehabilitation, treatment, that kind of thing. And again, in a CCR, developing meaningful leverage to get the guy into a program he doesn't want to go to and to keep him in that program is really important. I'll say one other thing about that. If you have a system that says, you got to go to treatment, and they end up in treatment, and then they quit going, or they start using again, and they get picked up or whatever, and then they send them back and they end up doing their time. That's not helpful, right? He's not going to change in incarceration. Incarceration has to be used as a tool to keep him in a program that's going to actually give him the opportunity to change. So you're using that leverage. So maybe, and this is what came up in that fantastic project, I don't know how many years ago it was, David, when the specialty court that Ann Arbor was part of, was that?
That was 2000.
20 years ago. Wow. Yeah. So, so one of the things that came out of that is that project was graduated sentencing. So instead of just taking him and sending him to do all his time, do part of the time, right? Parse out some of the time as a reminder that this is what you could be doing for the next 3 months or the next year, depending on how much time was over his head. So an example of that was a judge in Duluth had a guy in front of him, and he said, Your Honor, I don't want to go to this men's program. I just want to do my time. And he had like 90 days over his head. So what the judge said is, you know what? I'm not going to give you your 90 days straight. I'm going to make you check in to the St. Louis County Jail on Friday night, and you're going to be released on Sunday. And I'm going to make you do this until your 90 days are up, which was like a year of weekends. And he said, or you can go to your program. And he went to the program, right? Because he didn't want to spend a year in it was weekends in jail. That is leverage. That was meaningful. That motivated him to go. So that's the kind of thing that you can do. Use that time as leverage to get him into a program he doesn't want to go to. Yeah, so what Dr. Gondolf and Ellen are going to be talking about is the connection in research and practice between a sanction and successful rehabilitation. All right, Jeff.
How much does the model of being used in the program affect whether men who batter change or not? Or is there something about the arrest and the criminal justice system and sanctions, or is there a way to analyze that, or do you have any thoughts about that, either of you?
Well, yeah, there's no doubt that the court supervision and sanction, along with the persuasion and encouragement of the batterers programs, reinforce each other. And
if you've got a really consistent court response, when you send people off to the rehab groups, the deterrence is it's the combination of these two things. It's the criminal justice system steadily behind you, where people are coming into that and they're getting this option of rehab, but there's kind of some consistent surveillance to make it work.
Yeah, this has really become a kind of fundamental principle, I think, in the criminal justice field in general, that sort of so-called coerced treatment is more effective than either voluntary treatment or just sanctions without the treatment.
And that's true in other criminal behavior.
Yeah, it's really become a staple in the drug court approach to intervention that echoes a lot of what has developed and emerged in the domestic violence field. And the drug courts have been very extensively and thoroughly researched. And sort of the overwhelming consensus there is that drug courts are much more effective than the other alternatives.
Groups actually act as that. They act like, in my mind, they act the same as a probation officer meeting with the guy every week. They know this group is connected to that PO and that PO is connected to that judge. You wouldn't just cut out the court and just do group. But if you can't do a court thing, you've got to have something like a sanction. It's not one without the other.
And the striking statistic for us was that at 2.5 years after program intake, 80% of the men had not been violent in the previous year, according to their original partners and any new partners. And by 4 years, 90% of the men had not been violent towards a partner in the previous year.
Okay, so so that again is something that you're going to need to think about. How are you going to use leverage? In the United States, given how we've structured our government, our society, our communities, freedom tends to be the thing that is leverage. It doesn't have to be. I mean, there's other things that you can create within particular communities, but in general, in a city, freedom tends to be the thing that we can leverage. And so if you get somebody who's in a government system like the criminal justice system or in the human service system, and they want to get back into that house with their family, but they're not allowed in, or the kids get pulled, then that's leverage to get him into a process that he might not want to be in. So you just have to think through in your community, what is that going to be? And don't use punishment as the solution. Use it as the leverage to get somebody into what might be, for that individual at this time, a solution to the violence that he's been using. So thoughts, I don't know. So tell me what your communities are doing right now, right? Are they, if a guy ends up violating, does he end up doing all his time, or how does this play out for all of you? And has anybody thought through how to use this as leverage to rehabilitate?
The CCR that we have right here, right now, is with misdemeanor probation, and we're in communication every 2 to 3 weeks, at least monthly, about their attendance or learning and their fees paid and so forth. If they miss 1 to 2 classes, I'll get on the horn and let the PO know, and then they will speak to the client, and they offer them to go continue the classes, or the consequences to go back in the can, or jail, whatever. Sometimes it works, sometimes it doesn't. It's like on a case-by-case basis. But I like what you said. What'd you say? Not punishment oriented. I think I didn't.
Yeah, you're not. Punishment isn't your solution. Punishment's the leverage you use to get to a solution.
Right.
Yeah.
And then during the video, I saw, I believe, 80% success rate. I mean, guys who don't get violent, then 90% after 4 years. Yeah. Sure.
Go ahead.
And the tracking of that is kind of sketchy because they move, and like, I really like what you said, the vast majority of DV does not get reported. We don't know what happens once they leave the program, but we do get positive feedback when I call them up after the guys who have completed to come back as mentors into the program. They have nothing but good stuff to say, or they're too busy living life to be part of which is natural, to be part of our program. They moved on. And that moving on, getting a job, an apartment, back with the family, to me, that's one definition of success of the program.
Yeah. Do you have any, in New Mexico, can men's programs have victim contact?
Men's program. Elaborate on that, please.
Well, so like in some states, they prohibit men's programs from having any contact with victims. But I don't know in New Mexico if that is a rule or not. Or David, do you know what that is?
I don't believe there's any stipulation prohibiting victim contact.
Okay, great. Well, that's good. So David, one of the things that really I think can help you also is to have somebody in your agency who doesn't do a men's group contact the women whose partners are in it, and just see if the survivors want a relationship with your agency. And if they do, it's a tremendous source of information about what change looks like, right? Like he's not hitting me anymore, and I don't feel like he'd do that, but geez, the emotional abuse is just like picked up, right? Like that kind of stuff is so then you just know that going in, that the guy's saying, hey, you know what, I've really started to change, well, what's still the opportunity, right? Because right? Because you get that feedback, but you can't let him know that you know, but it helps you understand or have a little more confidence in what you're doing, and if victims are saying anything good about it, or if there's still opportunities. Like we used to give homework. We quit doing that because the women said, he's making us do it, right? So don't send that stuff home with him, you know? So yeah, that kind of contact can be really helpful to your program.
I don't know if I should say this or not, but I have spoken to girlfriends and wives of some of the guys. They'll come directly to me, or they'll say, he's changed. There's something different. I want to be part of this program. And that to me is a compliment to the program, and that it is a change factor. There's a different programming upstairs with this guy. Instead of doing this, he's being more empathetic or whatever. And just by getting those small conversations with wives or girlfriends about how he's changed tells us that there is an effect with the program.
Yeah.
Not all, mind you, but there bits and pieces. And I think that's great. But like you said about the homework, when we had physical classrooms, the pretty handwriting on the homework tells me he didn't do it. Big old loops. I said, who did this? Oh, my wife did. I said, no. I want you to do. I'll read anything you got. Give me your answers, not her answers.
Yeah. Yeah, we just quit giving it to him. Yeah, I actually testified in court one time, and I was able to prove, because that's how far this had to go, that it wasn't his handwriting, and he ended up doing a whole bunch of time. So it's just, yeah, but not, it doesn't work for everyone. Others, what's the process that you are using to leverage guys into rehabilitation, or not, or maybe it's not something you even thought through yet? Lester.
Oh, well, so to keep people coming, when they miss a couple of sessions, they meet with their compliance officer and me. And then we talk to them, we make a big deal about what's keeping them from coming. Usually that helps them continuing to come on a regular basis. So we have compliance and treatment in the same agency. And so if a client, so our program is 52 weeks, and when the client doesn't finish before he's off probation, the only hook we have is to give him an unsatisfactory discharge from probation if he doesn't finish. So we generally get most of the people continue to come even after our probation just to get that. And by the time they've been in probation for 12 months, they're usually pretty close to the end. So,
yeah. So one of the things we do in Duluth to that problem, Lester, is that the hook we have is that if you don't finish before your probation's up, we're extending your probation, right? And they don't want that, right?
We can't do that with magistrate court. We can't do that. It's over 364 days is finished no matter what. So they can't get an extension. So
our program's 6.5 months. So we got a little room to play there that you don't.
Right.
Yeah.
But generally that, because if they get an unsatisfactory discharge from probation, that prevents them from getting certifications, possibly licenses, depending on what their total charge was. And so it does affect them. So we get people coming back when they realize that, but most of the time people finish.
Okay, good. All right. So Angela, from an advocacy point of view, since I know that you're an advocate on the call, what kind of thoughts do you have about men's rehabilitation program, the leverages that keep them in, the effects that you're hearing from victims, your connection or not with that program? I mean, what's the landscape?
So I may have the attitude of an advocate, and I do provide advocacy within my roles, but I'm not primarily an advocate. So with respect to this type of involvement, I'm the sexual assault and domestic violence nurse. So I see them when they come into me for exams. And then I do more of the advocacy on the side of MDTs and we don't call it a CCR, but our you know, but anyway, is more on the professional level. So I don't, our domestic violence shelter, our battered women's shelter is who runs the BIPs, and we don't have a good working relationship with them. So I really don't know anything on that side of things.
Okay. All right. So that kind of fragmentation, right, in a community, when you don't have a good working relationship with another really important entity, it just makes it easier for these offenders to get away with what they're doing. I remember early in my go ahead, Angela, sorry.
No, I was just gonna say for sure. I mean, I absolutely agree. And we've tried to work at many different angles to build that relationship, but it just isn't reciprocated. So I mean, we're kind of stuck.
Yeah. Yeah. So I was going to say early in my work, when I was just kind of learning the ropes here, and Ellen said to me, because I had a real strong disagreement with the woman who's running the shelter, and we were basically at odds, like we just couldn't work it out. So then Ellen came down and she said, I'm going to mediate a conversation between the two of you, because the only benefit between the two of you not working together as agencies is for the offenders. And that's not okay. And you don't get to put your anger in the center. Her safety is supposed to be in the center, not your frustration, not your anger towards someone else, right? So that was a real kind of like, all right, thanks for helping me recenter myself and where I belong in this work, because I had made myself kind of the center of it. So, Jim.
So I think there's two different things that motivate clients. It's either motivation that program's actually going to make their life better, right? And then we have the deterrent, right? Deterrent is jail, and jail works great for middle-class men who haven't been incarcerated before. It's not really that great of a deterrent for men who've been in prison and stuff like that. They're like, F it, give me this 90 days. I can do that on my head, doing handstands. So you got to look at different motivating factors. For us, we started out from the day of sentencing, having judicial reviews and people who are getting off probation, getting off much like drug court, but different. We didn't celebrate them getting off, but when they got off, the judge would give them their discharge notice, let them know that probation had no jurisdiction over them, and neither did the judge. And she would ask what they honestly got from the program. Was it worth it? Was it beneficial? And the men oftentimes could report very positive things. And then when she went on to sentence other men, she'd be like, okay, Mr. Garvin, I know you're not happy right now, but did you hear Mr. Miller talk this morning? I hope a year from now, I'll be hearing that speech from you. So giving them hope right from the beginning. And then the other thing that we did was the judicial reviews and immediate consequences very quickly, and letting them see those consequences in that, so they didn't have to experience them. They learned through other people getting it. And then the final thing was just calling them. Like if I got notice that he wasn't in class tonight and I could call him and say, hey, George, why aren't you in class tonight? And he's like, oh shit, that's quick, right? I got to tell the judge in the morning why you weren't there. What do you want me to tell her? Are you dropping out? Oh no, this is going on. I have to know what's happening. I have to tell the judge right away. And that worked good as a probation officer. I do that now as a veterans intervention provider. And quite frankly, some of the courts don't care if they come. I have a lot of family court cases. They're just told, if you come, it'll look favorable. It'll be one of the things they consider about visitation. But I still call them right away and say, hey, I got to send a notice to the court. What do you want me to tell them? Why were you not there? And they're like, oh, you send a notice every week? And then they're like, oh, and then it helps with compliance and retention a lot, I think.
Yeah. So what Jim just described, go back to the principle conversation, the principles that we talked about yesterday, continuing engagement with the offender. It works, right? So that's exactly what that is. And that's a great example of it, in order to keep them engaged in what you want them to do. Yeah. We had in our Christian men's group, the thing that was keeping them engaged was part of what Jim was saying. They could see some value to it, But on the front end, it was really just avoiding consequence. But then eventually that shifts to, wow, I can actually get something out of this. I think I should go. But it was a group of men in that community, that faith community, that would meet on Wednesday night. The group was on Thursday night, but they would meet for coffee on Wednesday evening, and any of the men of the group, all the men were invited to go to hold each other accountable in their own lives as men. And that was that kind of fellowship that they were having and sharing together as men who were Christians was another thing that kept men in that process, because it was an added benefit that they were getting from attending that group. So there's a lot of ways to engage and to motivate, and leverage is one of those things, especially on the front end when you've got a guy who just doesn't want to go and motivation is not there. So hopefully the program changes that around as he attends, but yeah, good. Thanks, Jim. That's good. Anyone else share what they do or how they think about this? Yes, Lauren.
Yeah, I have to say the last individuals that are, what James said, I do the same thing. If I have a client that hasn't attended group and he hasn't made the effort to call and say, hey, Miss Lauren, I missed because of this, I do reach out to them. And I make it very clear to my clients that probation, adult probation and parole, compliance, we all talk. We have a very, very good relationship. And, it is kind of that scare tactic of, if you don't go to group, you have the possibility of getting a probation violation and going to jail. So I think they keep that in the back of their mind of, oh, I better get to group, or, my probation officer is going to be mad at me. But that's, something we use as well.
Yeah. And Lauren, who do you work for? I
run the intervention program for the Roswell Refuge in Roswell, New Mexico.
Okay. All right. Good. Yes. All right. So, next slide, Jeff. Let's talk about, Jim.
Well,
as soon as I said,
her clients probably get confiscated by the UFOs. That's why they're not showing up. But
Jim, I want you to know that I did not go there. I could have. It crossed my mind, but I
was
resisted.
disappointed. But hey, my other thing I was going to say is a lot of times when I make those calls, I try to work on kudos too. Like if the guy had been doing really good for so long, like George, you had been doing so good for so long. What's going on? What's happening? And sometimes just that data boy and then concern lets them know that, hey, they are here to help. They're not just here to punish me and beat me up. So I think just those calls can feel like some of these guys really haven't had a whole lot of people who cared for them, right, in my opinion. And that's why they're kind of so angry at the world and so controlling.
Yeah.
Anyway, fact, I'm sorry. I didn't mean to interrupt again. I had to throw the joke in there.
Yeah. So building on what Jim just said, if I had to pick one thing that was at the top of the list for men in our program who said, this is what allowed me to open up, look at myself and change, it was that the facilitators actually cared about what happened to me. It's big. And you're developing a relationship with each one of those guys in that room. And that kind of engagement is motivating. So yeah, don't want to lose the importance of that. So good. Okay. I thought when Jim raised his hand when I pulled this slide up that he was going to volunteer to be he moved to New Mexico and be the organizer. Okay. All right. So these are some of the things that I've put together because I've hired a lot of people at DEIP who've wanted to do this kind of work over the years. And there's certain things that I'm looking for in that person to be able to do the work. Grounded in victims' experience and coercive control and how men use it. I mean, it's really important to understand both how victims experience the violence and how men execute it, right? Because there's two things that have to be accounted for in a CCR, and knowing both of those is important. Confident, not intimidated by positions of power. Ellen said to me one time, she said, you know why I hired you to do this work? And I said, well, no, but and I'm a little nervous to hear. And she said, because you're not afraid of anybody. And I said, well, that includes you too, Ellen. So, like, but anyway, there are people that I've mentored who get in front of a judge and just shut down. They don't know how to navigate that space with positions of power, and that isn't going to work, right? You have to be able to find a way to talk to people who have all of this status or power or whatever it is in your communities, and organize with them and partner with them. That in my experience, that is one of the hardest things for me to find. You'd think it wouldn't be. I think it might be just a few. It's really the thing that really gets in the way for a lot of people to do this work. So, which is interesting to me. Organized. Yeah, so organized. We lose our internet today. Anyway, organized in a way that, like, I was sitting at a meeting, and there was an advocate across the table, and she was sketching out the conversation on graph paper, and it intrigued me. So I said, so tell me what you're doing there, after the meeting was over. And she said, well, I just love graphs. I love organizing thoughts into spaces and seeing how they connect. And I thought, okay, there's somebody. that's somebody whose mindset or filter is going to be good in this work, right? Because it isn't just like having everything in place. It's wanting to move things into place and find the best way that they fit. That's what I mean by organized. All right, patience that comes from a long-term vision. We've talked about that. Can see the matrix eventually. It takes a while, but eventually, I don't know if it's the red pill or the blue pill, but eventually you get that vision. Can write and read a lot. You produce a lot of written material. As reports, as mock or not mock, but draft policies or protocols. You're writing a lot, and the ability to articulate yourself through writing is going to be important. And reading. You end up reading a ton. You're reading other people, the work they've done in other communities and the reports that they put together, so that you're not recreating the wheel. You're reading a ton of policy. You're reading statute. You're reading through thick binders of policy to see if they have anything to do with domestic violence that might be helpful or contradictory. When we did the police policy for domestic assault, we had to go through the entire policy that they have for everything to make sure that everything else in their policy was consistent with the changes we were making in this 4-page domestic assault policy for the police department. Credible and can hold confidence, build trust. And again, we've talked about that. That is my currency in the system. I had a judge call me yesterday, just on a break, and he said, I need to have this conversation stay confidential. Right? That's what it is. But he knows that that's what's going to happen if he says it. And that's why I got the call. So, all right. Next slide, Jeff. Doesn't have a confrontational personality or track record, right? I am going to be facilitating a conversation next week in another community between entities that are really at odds, because the advocate was quite confrontational to people in the system. And I don't know if we're going to salvage the initiative, but that advocate's never going to overcome this experience, because those system folks, like, it's elephant memory, right? They don't forget. So I was in New Orleans, and they wanted to be part of the CCR, but they had this long history of exposing through the media the things that police were failing at. Well, you can't have 10 years of doing that and then come in and say, well, we want your police reports, and it's not gonna happen, right? So another entity had to actually take that that role in the CCR because it just wasn't going to work. So that's a really important characteristic. Much as a coordinator, a lot of anger comes to me. People who are frustrated with other people's actions or behavior. I can't take it on, right? It's just not, I cannot take it on. And sometimes they get frustrated with me because I'm not joining them in this anger fest. It's not going to solve the problem. It's just not, right? So I need to be disciplined to not join that party and say, okay, I'm hearing the concern and let me take it and go look and see what I can find, right? Collaborative, smart, curious, knows how to balance usefulness to the system and allegiance to victims and course of control. One of the things that advocates in the shelter have to, and the court advocates have to trust is that, so here's what will happen. An advocate's job is to push for what a woman needs. And sometimes that pushing can lead them to loggerheads with a practitioner. So then what I do, what happens with me is I get a call from that practitioner because I have a different relationship. And they'll say, man, I just had this case and the advocate called me and they just chewed me from one end to the other. And it's just like, dang, did I do that bad? Or like, what? They want to process it with me, right? Advocates have to trust. They have to know me well enough that I can process this with them and not sell them out, right? And that's a balance because I have their backs and I have the practitioner's back, because if everybody is together, we are going to be stronger and it's going to be harder for him to get through this system. But if I start, making comments about an advocate because somebody else is mad because I want their allegiance more than I want the advocates, or vice versa, then all I do, I only contribute to fragmentation. And then I'm doing the opposite of what my role is supposed to be doing. Right? All right. Lots of questions. If I'm a nerd, I'm a question nerd. I love questions. I love great questions. In fact, when they ask me a great question, I just start laughing because I get giddy. That's a great question. I love that, right? So you got to be full of them. You are there to find out, learn, and discover, and then take all of what you learn and try to recreate it into something that nobody's thought of and bring it back as an idea, as a proposal that might offer that three-legged stool: safety, accountability, and improved work experience. And then has the time to develop and not be responsible for individual advocacy if that can be organized. Because every time I've seen it tried, it just doesn't work very well, because individual advocacy that pool is deep and it requires so much time and effort and energy but anything left over just is not enough for what we're asking of this position to do. So that's kind of like the list. David?
I want to ask kind of the inverse of a question. I was going to start with, are there any professions that you think prepare people well for this? But what about professions that you would avoid? So for example, is being a coordinator like this something that a criminal justice person could do, the average criminal justice person versus a social worker versus any other of, or do you even need any kind of degree at all, or in an affiliated field? I mean, you're a great example, and you shared that your philosophy background.
Prepared for everything and nothing all at once. Yeah. Well, I've known people within every system who could do this. I don't think there is a personality that can be in corrections. There's a personality in law enforcement that can get in the way of this for sure, right? You really need to have a flexible imagination, right? It can't be this, and this, because it just doesn't work that way. It's always the gray that you're working with in between that where the solutions tend to be found. So yeah, I think accounting would be a tough profession to come and do this work from.
Okay. Okay.
Yeah, it's a really interesting question. I have to think about that. Because I think I know collaborative people in every agency that we work with in the CCR. And I know people who are not collaborative. I know people who are advocates who are not collaborative in the work that they're doing.
Mm-hmm.
So yeah, I don't think I don't know. I don't think it's agency contingent or profession contingent. I think it's a personality you're looking for. And I think you can find them in almost any, yeah, and you don't need, this is not a degreed program. It's like Muriel, when the defense is, and you don't have a degree in domestic violence. And Muriel said, Mr. Miller, is there a degree in domestic violence? Not a degree in domestic violence.
No. No.
So, yeah.
Then, and a follow-up question is, are there things that you've seen people do that fall into various categories, organizations who bring on somebody like this that is just a bad idea to do? So for example, somebody who says, yeah, we got a grant and we're going to fund this position and we're going to pay this person, and then they don't do anything to support them. I mean, that kind of thing. What's the list of the don't do this kind of things that we should all be thinking about?
That's good. That's a new slide. Jeff, we got to take that note. That's a slide. All right. So one of the things that happens is we got this money and the position has some profile to it, right? Because you're going and you're meeting with all of these different government players. And so sometimes the ED of an agency will say, well, because this is a high profile position, I'll take it on. And they don't have the personality for it. It's just not who they are. Or they don't have the time for it or whatever, right? Now I'm an ED here, but the only reason I'm an ED is because I'm the last one standing. They had to give it to somebody, right? So you're looking for a personality. You're not looking for a position to take this job. So I think that's an important one. The other one is, and this happened in a community that I worked in recently, did some consulting in, they did exactly what David said. They hired a person into the job. They didn't invite anybody from the CCR to be part of the interview committee. They just hired them outright. And they didn't support them because they didn't understand the work. They got the money, right? It was a GT grant to encourage arrest from VAWA. So the money had to go to a government entity. And then they contracted with an advocacy agency to hire somebody to do part of the coordination effort. And they just flopped because nobody gave them any guidance. They didn't get any support. The agency didn't really believe in it in the first place. And it just floundered. So those are two big things that I see that are problematic.
And you suggested something about the interview committee. I think that's a beautiful thing. I know that when I've hired forensic interviewers for a child advocacy center, I always included a hiring team from the MDT, and that made a world of difference because that was a position that was going to interface with all of those systems, and it was important for them to have that buy-in. They understood the final decision was with the organization who was making the paycheck for the person, but that they had a strong voice in that. I like that idea.
Yeah, in fact, I remember that when we put our domestic violence response team together, we sat down with the sergeant that was going to be in charge of the investigators, and then me, who was going to be in charge of the advocates who worked on that divert team, and who else did we have? We had a prosecutor and a probation agent, I think. And interestingly, it wasn't even in my lens, right? The sergeant from the police department, we interviewed a couple of people, and I thought, well, I think they're pretty good. And he said, no, I don't think so. And I said, why is it? What's your concern? I don't think they're going to survive with that personality and with a bunch of cops. I don't see it. It's going to be a rougher environment than I think they're going to be used to, and I don't think they're going to thrive in it. And so I didn't have that lens, right? And at that time in that department, 18 years ago, that was true. They needed to have, and so that the people we ended up hiring actually thrived in it. In fact, Pat, who's doing it, has been there the whole time. She's the one person who's stayed, and she can operate in that space. So that's a culture. Will they fit into it? That wasn't my lens, so that was really helpful.
Good.
Yeah. And then they brought us in to be on the panel when we hired when patrol officers were applying for the investigator position on the divert team when there was turnover. So we got to be on that panel, right? So yeah, we're all taking responsibility for who we're going to work with. It's good. Any other questions or thoughts that you have? Christina, I see you've moved to Christmas. All right. Next slide, Jeff. Okay, so what we're going to do is take our break a little bit early, because I don't want to start this, stop it, and come back. So we'll take our 15-minute break, and then we're going to come back, and we're going to Teresa, are you on somewhere? I'm not seeing Teresa.
She may be away from her computer, but what do you need?
Well, she wanted 15 minutes to put the teams together
Okay.
into a small group. So if you could let her know, she just got her notice for 15 minutes. So we'll come back. You're going to end up working with your teams and kind of going through an agenda that I've set up. So we'll talk about that when we come back. But enjoy your break, and we'll see you soon. So David, did we get the groups squared away?
As far as I know, Terry's got that handled.
Okay, great.
Scott, is that Camilla coffee?
This is rooibos tea
Okay.
with an excessive amount of honey in it. Yes, yes. And nobody would make that up, Lionel. All right. I don't see Teresa on the screen.
She's
I am on
here. There she is.
There you are. There you are. There you are. You're making me nervous, Teresa.
No, you're good. There's a couple of people that I still need to put in their rooms, but so far, I mean,
Okay.
we're good to go. We do have a couple of rooms in the areas, you know, in New Mexico that only have 1 or 2 people. How would you like me to address that?
Yeah. So if they could just join another team from New Mexico, that would be great.
Okay. So you all should have options to, if you have the most updated version of Zoom, I do have some rooms open that if you feel that you might fit in that one, if you only have 1 or 2 people in your room, go ahead and click join on that. And then for those that are, you know, left with us, I will put you in a room. So did you want me to go ahead and open those now?
No, just we'll wait for just a minute.
Okay, perfect.
Yeah, because I want to cover a slide first, give you a little time to figure that out. Okay, Jeff, do you want to bring up the last slide? All right, so next steps in your CCR, just some ideas, right? What we want you to do, what we want you to accomplish by the end of this conversation is have a plan, have a next steps, and why. What is your plan and why, right? And then we'll come back and share some of that stuff. And then again, I want you to email that to David, so he has a copy of what it is that you're planning on doing. So here's some ideas. What are some structural changes that need to be addressed? Accountability, like example, accountability to each other, to victims, meeting format, focus, right? So are there people that need to be hired? Are there people, is there things that need to, relationships that need to be mended? Are there structural things that need to happen? Is that the primary thing that should happen next, right? Or what do you know about your current practices about victims and battering? What would be the next step? Do you even know how your system works, right? Do you maybe know how your agency works, but do you know how everybody else processes these cases as they come through, including community agencies? Is that the next step, right? Does your CCR response focus more on how to manage offenders and victims, or is it designed to improve the lives that you serve, right? So are you doing more management of cases that come in to your CCR, or is there a filter where we're trying to make sure that we're actually improving their lives, right? Is that something? So if you've got a CCR in place, maybe that's an option, right? We should consider, are we doing anything to benefit the communities and the people in it lives? Or are we just managing people for as long as we have them? And then what are key agenda items for your next meeting? If you are set up to have judicial council meetings, what would you like to add to the agenda that you got out of this training and bring that to the council that you're currently on? So depending upon how you're situated, one of these four might be more relevant than the other. So so within your community group, you can pick what that is. And if you're not, if you're like you're one person from a community, you can be part of listening to how another community is putting this together and maybe generate some ideas for yourself about what you want to do moving forward with the community that you're in. Okay. All right. Any questions or thoughts about what you're going to do in your small group? Are you sure, Perry? You got no questions?
No, I'm ready. I'm ready.
You're ready. Okay. All right. So you're going to get an invitation. I'm guessing we're not running these on our end now. So the invitation could go out now, Teresa, and then I'll jump in. We're going to do this for a good half hour. So I'm going to jump in and just see how things are going and see if you have anything that you want to ask me. If not, I'll move to the next group. But yeah, you've got some time to put this conversation together. So the invitations should be on their way. So are we all back? It looks like we are. All right. Okay, so David, where are you?
Okay.
Did I lose David?
No, I'm here.
There you are, there you are. Okay, so I said 30 minutes, but I've been to every group and we worked right up until the last minute here. So so there's been a lot of it. I don't know if you're going to get a plan because a lot of us kind of got to it right towards the end, at least the groups that I was jumping in on. So but what I'm going to encourage you to do is when you put that plan together, like one of the places was tell I'm gonna miss
consequences. Tucumcari.
Tucumcari, right? So they don't need to have a meeting to get to know everybody because they already know everybody. So so I said to increase their ability to, like, if they do a series of focus groups, in their community about their current response, to call up the coalition and ask them to be on the analysis of their focus group results, so that they can, so you have more, basically, if you don't have the staff there, partner with the coalition to help you to go through that. So I made a lot, I offered a lot of services from the coalition. I want Teresa and David to know that as I was going through all of the groups. So yeah, so this was the small group work was great. Pam, you got your hand up.
Yes, I just wanted to take just a second to since you were bringing up the coalition, can I take 2 minutes? I know that we're kind of crunched up for time a little bit. First thing I want to do is just acknowledge all the people that were here. I know some of you, but there are a lot of you I don't know. I just realized I'm wearing headphones, glasses, and a hat, but you know, oh well. And I want to thank, obviously, Scott and Jeff, David Garvin for putting all this together, Terry for keeping it all organized for us, all of you for being here. I think this was fabulous. But what I really want to say is that this isn't the end. It's the end of this 3 days, but it's not the end. And the coalition, I'm sure I'll volunteer Terry and David and other people who aren't expecting
Why not?
it.
I've been doing it all day.
Why is addiction a disease? Okay, good. Okay, all right. So I'll be volunteering people to really help us think about this. And I hope that you all stay in touch with us because I think we have kind of a roadmap. So if y'all just stay tuned, there's going to be more. I'm not exactly sure what, and I'm not exactly sure when, but there is going to be something. This was too good, and I think there's too much hope here in all of this to not continue it. So thank you so much for all of you, and Scott for an unbelievable 3 days. I thought I'd never make it through 3 days of this, and I was like interested the whole time. So there you go. So thank you all, and thanks for letting me say that little piece.
I always play down expectations and try to exceed them. That's what I do. All right. So yeah, there's a lot of good thinking and ideas in all those meetings that I've just spent the last hour in. Yeah, some of it's statutory considerations, some of it's local stuff. A lot of it is starting to actually ask survivors in your communities what it's like when your system in your community intervenes in their life when they call for help. That's where I think a lot of you need to probably start, because that's a definite gap in most of the folk with most of the communities that I was just in. So yeah, it's been really a great opportunity, fun to be part of this the New Mexico Coalition training. And David, I've known a long time. Teresa, I know now. Pam, I've known a long time. I really appreciate the commitment that you all have put forth, and your state has, as we heard today, a real opportunity to get better at these cases, right? So you're in anything I can do in the future, I'd be happy to come in and individual to consult in a 1 hour conversation. Sometimes it helps to bring somebody from the outside in because, like David, for example, he's from the outside. Somebody from the outside in and to a community, because there's politics, there's relationships, there's all kinds of things that make it difficult for somebody in a community to have the leverage to get things going. So if that helps, make that happen on your end. So yeah, that's what we've got. I hope it was helpful.
Scott,
David.
Scott, I also want to thank you. Pam, thank you for all of your kind words as well. Scott, you've made learning fun, which I think is key to doing this work and sustaining this work. I want to say again to everyone, hear what Pam said, that we're not done with this. We're getting started with this. Let us know what we can do to support you. I've been saying that for the last couple of days now. Let us know. I've said this to a few of you already. If you have CCR meetings that are going on and they're open to the public, please let me know about that. I would love to come to one of those meetings, assuming that you're having them virtually, and just kind of sit in on it. I would really appreciate that. I'm going to turn it over to Terry just in 1 second, but this is the number 6 training out of the 7 series that we're putting together for the CCR training, and for a total of 30 hours. You know, we've punched your time card a lot in the last number of weeks. But the next one is next Wednesday. Terry's going to tell us more about that and is going to tell you all about getting the certificate and getting your evaluations and all of that. So Terry, take it away.
Thank you so much, David. And all the things, I have to say thank you to you all as well for putting this training together. And David, thank you for all of your work. Scott, it's been fantastic. As you all saw in the chat, I did put our link for our MailChimp listserv. Again, it goes out only on Mondays, once a week, just to let you all know what trainings we have coming up that week. And then the following week, and any announcements that we have at the coalition. There's a lot of stuff happening due to the legislative session. We do have community heroes that are going to be honored as well. So for our programs, if you are on, just a little reminder to please honor your community heroes. If you have anybody that has really impacted your organization, please let us know. That form is also out there on our training listserv. It only goes out once a week. Again, please follow us on social media, Facebook, Instagram, YouTube, Twitter, and we are redoing our website currently, so I'll keep you all posted with that. And I did also place the link for your certificate. Please complete that survey. We really want to get your feedback. The past 3 days have been absolutely very interactive. Have already received positive feedback on it, but we really want to get it on paper and also send it to Scott. And see if we would, if you all would be interested to have this in future, which I think would be an absolute yes. Please, let's have it. And so there's also other information and questions in the survey. And once you complete that, you will attain your certificate for the 3 days. I will be emailing it as well with the documents that Scott has sent the past 3 days, just in case you all have that in an email and don't have to worry about saving and it possibly getting lost. As David also mentioned, we do have the training next week on the 15th. I'm going to put that link as David closes us for the day. If you have not registered, please register on that link. It is the same link if you have already attended our past 6 CCR sessions. So there you don't have to re-register, and I will send you the link as well the day before and the morning of, so you all have it in your email and don't have to struggle to find it. Again, if you have any questions or concerns, please let me know how I can support you. And as David said, please let us know how we can support you with future CCR meetings. We would love to attend and support you all. And I hope you all have a fantastic day. And thank you again for participating with us for the 3 days.
Thank you, Terry. And just a quick note on what that session is next week. It's next Wednesday from 1 to 3. And it is with 2 folks who are the next Ed Gondolf's coming up in this work. Ed has retired. So Eric Mankowski and Chris Hall. Chris is getting close to having his PhD and is going to be diving into the deep end of the pool of this work. Both of them are going to be helping all of us be more literate when it comes to reading and understanding research, which I think is really important, because if you're like me, you pick up a piece of research and it's a great sleep inducer. So this will help us understand what we're reading and be able to make it be part of our vocabulary. When people say, "Hey, does your program work?" You'll be able to have some ways to answer those questions in meaningful ways and be able to quote the research and also know what it means. So please join us for that. Thank you so much.
Say, David, I got to tell you, the last hour since the break, this presentation has been brought to you by T-Mobile hotspots. I'm amazed at the ability of this. This was actually, we bought this as a backup, we never had to use it. It works actually as good as the regular internet. So another little technological thing to get. So yeah.
Good.
Well, thank you. We'll see you all.
Okay.
Good luck. All right.
Bye-bye,
take care.
everybody.